Welcome, guys. This is the Cardboard Castle. I appreciate you guys for showing up. I, of course, am your host, Alex. Today we have Mart. Oh, I have feedback. 1 second, guys. Today we have. There we go. Sorry about that. Sorry about that feedback. So again, going back to where we were. So today we have a expert with us and a great guest, my personal lawyer and personal friend, Matt Barton, above me. Matt, if you want to introduce yourself.
Hey, I'm Matthew Barton. I'm the one of the partners at Barton and Doomey out of Salisbury, North Carolina, and I love constitutional law, so I'm looking forward to tonight's discussion.
Mhm. Awesome. And by the way, I know we have six to nine people in our community that are North Carolinian citizens that don't know me. But if you guys ever need legal help, this guy is a great guy. Again, that's Barton and Doomey, and they practice out of Salisbury. Jay said, "Oh, there, Jay the Giant Pizza goes. He's an attractive lawyer. Just got to put that out there. You know what? I ain't touching that with a 10-foot pole." So we're moving on. He is married, so we're just gonna coast. All right, so moving on. Guys, we're gonna start off our night, of course, as the usual. We're gonna go over what's currently the situation in Ukraine. And then we'll have some more feedback from Matt and others like him, because we're gonna talk about the chilling effect of the Roe v. Wade decision, what Roe v. Wade is really about, what is stare decisis at its root, and get sort of that information from someone who is a legal professional, not just someone who's worked with legal professionals. So that way I don't have to be doing the disclaimer of I'm not a lawyer, I don't know law, consult your legal we don't have to have that tonight. So all right, so it seems that the Russian military, so I called it a few days ago, it seems the Russian military has decided to fully withdraw from the Izium axis and reinforce their lines, which is a smart move on their end because they have been losing mad ground around Kharkiv, and with the Ukrainians being within artillery range of them, they have just been getting pounded by Ukrainian artillery. Ukrainian artillery, the new artillery pieces that we've trained them in and given them, have really created a problem for Russia. They've just been getting massacred, along with the two artillery radars that they already have in theater. The response times that they're able to do with the new training they've been given and the new equipment they've been given with the M777 howitzers, along with the German artillery pieces and the German radars, have allowed them to be able to basically set up their artillery, find targets, lay ground fire quickly, and then move again before they can get hit back. Um, Luna says we do be doing a lot of disclaimers. Yeah, Luna. Hey, when you get your next speeding ticket, you can call this guy. So no, so it's crazy on the Russian front. So Ukraine has basically officially declared victory in Kharkiv. They've won that battle. They prevented Russian troops from encircling Kharkiv, and then stopped them from seizing it. Period, and expelled them from not only around the cities but from also around the villages and the entire area around there, basically the county. They're getting their asses kicked here. Russian troops basically try to continue their advance around the periphery of Izium since they've not been able to get it. But the Russian generals seem to be pulling back their BTGs back away from the northeast, moving to try to protect the Donetsk area and reinforce themselves and move for a long game of 4 to 6 months of being able to train forces and actually reconstitute their BTGs with forces that are not heavily demoralized from destroyed BTGs from the north or other areas. Also, Mariupol. In Mariupol, we know that the Azov basically holds one area. That's the metallurgy plant. They're still holding out. There was a conference between them and Turkey to try to work out an agreement to evacuate the leftover fighters from the Azov battalion. That seems to have stifled somewhat. There's not a lot of news coming out of that conference. And those guys have continued against all odds to persevere and survive against a Russian onslaught down there, where they should have fell, days ago, in my opinion. But they continue to soldier on, and that's basically because of the complexity of the tunnel systems they're in, those tunnel systems are, of course, built to withstand nuclear bombs, so it's very hard for conventional weapons to impact those, which means that infantry forces from Russia really have to go and try to take those tunnels, and they're just not being able to do it. So you guys, it's linked in the podcast subjects. You guys have seen me talk about understanding war and know that I'm a fellow with them. So you guys go check out that article if you really want to see it. We're going to sort of skip a little bit ahead. We're not going to do a lot of international news tonight because, Matt's time is important, and yeah, they try hard and are in Little Tunnel Fortress. Yeah, they are in a Little Tunnel Fortress. By the way, North is actually Ukrainian and from Ukraine, but he's here in the U.S. So when you guys see him talk about, he knows before you go arguing with him, he might know just a little bit more about Ukraine than most, considering its country of origin. Um, so all right. So beyond that, oh, they unfixed it. There we go. So we see that there's basically these are the major combat areas where there's a lot of combat going on. We can see the continued attempted encirclement from the north, but what you'll see here is that there is a new formation of blue down here on the bottom, and this is where I was talking about where they're going to attempt to horseshoe this extension where they're trying to create this. So this area right here is called the cauldron. So between down here in the bottom all the way through this loop through Donetsk, up through Luhansk and back. That's called the cauldron, right? So when you form a cauldron, you seal the top and you boil the forces that are inside, right? It's weird where some of this military terminology comes from, but if they were able to do that, the Ukrainian forces that are trapped in here would be in a really bad position. So what they are using is they're using Kharkiv as a launching platform to sort of move down to the south and create a horseshoe form to stop the cauldron from creating its top and destroying their forces. It seems that Ukraine has dedicated a large majority of their military might to doing this. Uh, and that's really where we are. The next 36 to 48 hours, we should really see a large increase in the Ukrainian advance and along with the Ukrainian military moving forward into these forward lines to try to complete the horseshoe. They've also continued to try to push around Kherson. Russian forces have been reinforced through down here in the Crimea, off of the Crimean Peninsula. Russia has been able to bring in forces to reconstitute their BTGs down around Kherson coming out of Crimea and have done so successfully. The Crimean bridge was heavily damaged, but it was not destroyed. And they were able to quickly use steel beams and other things to repair the damage to allow at least heavy transports to cross, even though it's somewhat dangerous. So that's where we are today, guys, inside of Ukraine. Other than that, most things haven't changed across the board. They continue to launch missiles. Uh, the Russian forces continue to be heavily demoralized. They aren't making a lot of progress. They are having to retreat. Around Kherson, they've gotten reinforcements, but we're not sure how long those are going to last, given how the war has been progressing. And the generals that have been killed have been all confirmed now. The ones that have been claimed to have been killed, and the general staff of Russia have had a huge and major change to the basically the what's the guy called the Butcher of Aleppo has taken control of all forces inside of Ukraine and move forward to sort of change the direction and repurpose and reimagine how they're advancing inside of Ukraine. And I think he might be a much more effective military leader, but we'll see, because the problem isn't entirely leadership. It's also their ability to support their units and also to have effective military equipment. And this is what happens when you have people who are basically embezzling from the every level. Someone was taken off the top, and when you take 10% at every level, eventually you end up with nothing. And well, that's what Russia's finding out. So there we go. All right, you got anything to add to this, man? I know this isn't exactly your forte, but
Were you talking to me?
yeah, I was saying, you got anything to add to this, man? Or I know this isn't exactly your forte, but
Honestly, it resembles to me kind of the Russian strategy in World War II against the Germans. As the Germans got closer to Moscow, this is a pretty typical Russian tactic. Doesn't seem to have changed much in 80 years.
Yep. And Ukraine's been really smart. They attacked their supply lines instead of trying to go up against a force that was bigger than them originally. It's been brilliant from a strategy perspective and from a psyops perspective, creating Ukrainian heroes like the Ghost of Kiev out of nowhere, and more, morally demoralizing their opponents and increasing the morale there. And yeah, it's been crazy, man. The other thing is Russia has just failed. So there's two things. One, Ukraine has done really well in creating morale and other things, and Russia has done really poorly in execution. So those two things combined has just led to a Ukrainian onslaught against them. Ukraine has went from defending to now being able to attack and take back. It's insane. And Northern Lights said
Again, it's
exactly.
really not that much different, though, than their campaign
Mm-hmm.
against the Germans in the early 1940s. If you look at the Russian military successes before Zhukov took over as the commander in chief of the Russian forces, it's no different than it is here. Very little progress, getting overrun, supply lines choked off, lots of tanks lost, lots of prisoners taken, and it really took change in leadership of the army itself before that really started to turn around. But what Russia always has, if they can ever get it together, is a huge industrial capacity, much like the United States does.
Yeah.
So they have that industrial base, and they can throw a lot of resources at the Ukraine if they really choose to.
Yeah, I can agree with that absolutely. It all depends if they have the currently I think what's limiting Putin right now is his political capital. So I think he's expended a large amount of it with launching this invasion, and with it not going to plan, he has to be very careful because he has put himself in a position of weakened empowerment in my opinion. But yeah, absolutely. I'm actually impressed. I didn't know you were much of a historian, a military historian buff at the so
I
awesome.
read a lot as a kid.
You read a lot as a kid. Understood. All right, guys. So we will be moving on. So the big subject of tonight, guys, it's Roe v. Wade. We're gonna be talking about. You guys heard me talk about stare decisis, and basically what that's about, and that really has to do with precedent and how that works. But I'll let the guy who's an expert in this. We'll sort of talk to him about it and sort of understand. But let's read what we're talking about. Um, so basically, it was written in the New York Post back on 5/3 that if the person who leaked the Supreme Court's draft opinion striking down Roe v. Wade was seeking to alter any of the justices' final opinions with public outrage, the move was a mistake. Legal experts, uh, basically, they're saying that this can have a really, um, because of leaks and other things like that, it can have a chilling effect on the justices being willing to put themselves in a precarious position from a political perspective, because the superior court judges are supposed to be apolitical. Their job is to understand and basically uh, see if a law is constitutional, and in the situation that it applies to this specific case, is it a proper and appropriate ruling, and other things like that. So first, let's start off. Matt, what can you sort of explain to us what stare decisis is and what it sort of means, and how it affects, judges and how they rule on things?
So generally, it's Latin for it stands decided,
Mm-hmm.
which is basically means that we've already done. This is the rule of
Mm-hmm.
law, because we've talked about this before. So if this is the rule of law, then whatever facts are in any particular case, that this particular rule has to apply to those facts. Um, there's a more disagreement about the limits of that policy than one might think. Um, there's a really good case about it from the early 1990s. It's a Eighth Amendment case, Tennessee v. Payne.
Mm-hmm.
Um, but Justice Brandeis, who is an older justice who has a law school named after him somewhere, as I recall, says basically adhering to precedent is usually the wise policy, because in most matters it is more important that the applicable rule of law be settled then it'd be right. So it promotes consistency in determining cases. Now, the caveat to that being that that type of philosophy has more importance when you're dealing with contract cases than it does with constitutional rights cases.
What
And
are
a lot of
contract cases versus what does that mean?
cases involving interpretation of contracts between business entities, or when people agree to do certain things as businesses, as individuals and businesses between each other. Those types of things, you need reliable and consistent rules, um, more so than you need an individual result to be right.
Mhm.
When you're talking about constitutional rights, you're talking about things that are extremely important to people and to liberty, and to faith in our system of government. So that principle of stare decisis is not as strong because it actually is important that we get it right in any particular case. So it's weaker in cases where you have constitutional rights at issue than it is where you have a contract dispute at
Okay.
issue. So, and the law can be very, very harsh, especially especially if you're the one on the losing end of it.
Understood. Understood. So basically, stare decisis says that if you're in a case as a judge, you should try to adhere to precedents, except in rare occasions where that precedents may not fit the facts that are specific to that case. Right? Is that am
Correct.
I okay? All right. So with stare decisis and the Roe v. Wade, it seems that the Superior Court is sort of going against stare decisis with their current finding of Roe v. Wade, from what I'm seeing. And is that unprecedented, or is it normal for long-standing precedent to be overruled sometimes because it later comes to light that maybe it stands on bad constitutional grounds or other things?
It happens less often than you would think. But even in Tennessee v. Payne, they talk about the Supreme Court during the past 20 years, between 1971 and 1991, has overruled in whole or in part 33 of its previous constitutional decisions. So it's not unheard of. I think
And
what
Tennessee v.
people are
Payne
going
was
to
a murder case, correct?
correct,
Okay, just make sure.
and ultimately it was a victim impact type statement, and the Eighth Amendment's about cruel and unusual punishment and proportionality and that sort of thing.
Okay.
So, but it has some of the best constitutional scholars in a couple generations were participants in that case. You had Scalia, who, whether you agree with him or not, was an incredibly intelligent man and a great thinker,
O'Connor.
and a very good writer. And you also had Justice Rehnquist, who I used to call him Starfleet Commander because he started putting those stripes on his robes. But when it came to being analyzed, when it came to analyzing cases, he's smart. And there's very, very few Supreme Court justices over the last 100 years or so that really understood federalism, or the interplay of power between the states and federal government to the degree that Rehnquist did, and how the Civil War changed the way federalism worked in this country. And Rehnquist was super good with that. He understood all of that. And really, that's what this leaked opinion is dealing with. It may be dealing with abortion and laws restricting abortion in Mississippi, to be specific, but it really deals more about what is the role of the judiciary, or the Supreme Court in our government, in our system of government, with the courts being their own branch of government. You have the legislative, of course, the executive branch, and then the judicial branch. What is the role of the court? But then the real issue is, underneath all of that, is one about power between the states and the federal government, but really specifically what they're addressing in this particular opinion, the undercurrent is the power of the state versus the power of the Supreme Court. So it really becomes a question of judicial activism, or at least this court's makeup, considering Roe v. Wade an act of judicial activism, and I think they have some really good arguments about that.
Absolutely. So are you familiar with RBG's standing and opinion on Roe v. Wade?
Not without reviewing it, because that's
Yeah,
something that you take in law school
yeah.
during constitutional law, typically in the second semester, and that for me has been about 12, almost 13 years ago.
Understood. Well, she felt that it was the wrong, so she said it was the wrong legal vehicle for the delivery of what it was meant, of what it eventually came to be, right? Um so the thing that I'm wondering is, so I think that the release of this, it seems that the release of this was meant to pressure the justices to sort of change their mind under political pressure. Uh, and
Mhm.
the Supreme Court is supposed to act independent of politics, of the executive branch, or the, I just lost my words, Congress and Senate are called the
Legislative.
legislative. Sorry, I apologize. The legislative branch. Um, can you speak to sort of how this could set a precedent, a very bad precedent of political pressure, and why is the Supreme Court supposed to be independent of these political pressures? Like, why is that important? Because that's a question I couldn't really understand. Like, why should they just be independent of politics?
Because they're a check in the system.
Mm-hmm.
And judges have to have fearless decision making in order to function as a check in the system. So we have what's called a tripartite or three-party or a three-part system, and each of these parts kind of intertwines with each other,
Mm-hmm.
with most of the power being in the legislative branch or the people's representatives to enact law. The check on that at the first level is the executive branch, because whatever law Congress passes the federal level, and the same at most state levels, because they're all structured relatively similarly,
Mm-hmm.
the governor or the president can set policies within his administration, choosing to enforce or not enforce particular laws, or choose how they're enforced. You know,
Through
you see
instruction
that
to the
as
DOJ, right? Yeah. Go ahead.
correct. I think probably the most relevant the most relevant example right now would be your immigration laws and
Mm-hmm.
how the Biden administration chooses to enforce those. With deportations um, being markedly down. So, as opposed to previous administrations. So the executive branch, the law doesn't change. The immigration laws as they're written haven't changed much. But how the executive branch has chosen to enforce them is has changed with each president. Now, let's say that let's take an example back from the 1830s. All right, the Indian Removal Acts.
Mm-hmm.
Um, they were legislatively driven and passed. Executives, executive branches, governors, presidents, because I think Andrew Jackson was actually president during that period of time, um, enforced those and were trying to forcibly remove Native American tribes from their traditional homelands. What people don't realize is that there is a Supreme Court opinion from that time that says that it's unconstitutional to do what they're doing. So the Supreme Court was trying to function as a check, saying the Constitution forbids this. We don't need to be, this is not something that we're doing. And the response from the president was Chief Justice Marshall has made his ruling, now let him try to enforce it. So what that talked about was what Jackson knew that most people didn't is that the judiciary, even though it was a separate form or a separate branch of government, lacked an enforcement mechanism to carry out its decisions. But that's all changed. So now what we have, it truly does function now like a true check in the system. So we've got a Supreme Court that can make rulings and they are enforced. And so the federal government, if they say, they tell the federal government, hey, you can't do this, they don't. Or
Yeah.
they tell the state governments, hey, this law is unconstitutional, you can't enforce it, it's not enforced. So it's different now, but they're a check in the system. And
Yeah.
they're meant to function as kind of a stopgap or a break,
Hmm.
in case, let's say for instance, in the case of gay marriage,
Hmm.
that was a hot button topic for everybody. We had the bathroom bill here in North Carolina, which was not even sure not even sure why we went there, but
Yeah. Cool.
whether you agreed with it or not, what the Supreme Court talked about was, the states just don't have any real rationale in this day and age or in this time period to distinguish between same-sex couples and heterosexual couples. There's just no real principal distinction between the two in terms of the function of marriage. So this law that discriminates on that basis is not constitutional, so you can't enforce it.
No,
So
understood.
that's what our Supreme Court functions from under Article 3 of the Constitution. There's a lot of really good early case law that talks about what the limits to that are, and you know what types of cases the Supreme Court should be hearing. And if you really want to get hyper technical about it, some of the stuff the Supreme Court hears now isn't stuff that constitutionally they're allowed to hear, but it's stuff that the Congress has expanded their jurisdiction to let them hear.
Understood. Well, I mean, there's also I know from my own experience working with you and other lawyers that I've worked for, um, that there are times where appeals courts, such as our circuit courts or the Supreme Court, can actually pick up cases where normally there's not a circumstance in which they have an ability to review a case, but they're asked to, and they decide this is of such great import to the law and other issues at hand that are underlying a ruling, that they still review the case and they bring it up into the circuit. I forget the technical term for it, but
It's a discretionary writ, so writ of
yep,
certiorari, basically, that
yep.
they issue that brings the case up. The funny thing about that, and people don't realize this unless you actually get kind of down and dirty with what what the real judicial power or what the real power is in the federal government. Congress could abolish every appeals court and every federal district court in this country constitutionally and limit the Supreme Court's jurisdiction to only those cases mentioned in Article 3, which would basically limit them to cases coming out of the state courts,
Hmm.
state against state, um, constitutional issues coming out of the state Supreme Court. But the federal courts only exist because Congress says they do. They don't have to be there constitutionally.
Yeah, understood. All right. So the other thing for me is understanding. So that gets back to why. So there's a question right now about, oh well, there needs to be term limits on superior court judges, or just superior court judges need to be able to be recalled, etc. And so if I understand what you're saying correctly, that basically the reason why the Supreme Court is a lifetime appointment, and it's supposed to be is because it's supposed to be apolitical. And if they make a decision that one political party or another doesn't like, they're it's trying to make them immune to those consequences, so that way they
Correct.
don't make their decisions politically.
Right. And they should be making their decisions based on the rule of law and case precedent, the common law of England, not so much on which political party is in power. And the calls that you hear now, for term limits and things like that are merely an extension of the cancel culture.
Mhm. Tarkin, what do you mean SC? Because for us here in North Carolina, SC in capitals means South Carolina. Do you mean the Senate, or if you could clarify for me briefly? So she said, what is the process the SC goes through? Oh, Supreme Court goes through once a case like Roe v. Wade is sent to them. Well, they don't get sent cases like that. So basically, the process is that you have to have a party that's injured in some form in which needs relief, right? And so, without an injured party in a specific case, not like Roe v. Wade, Roe v. Wade was a case and it set a precedent, right? And correct me at any time here, Matt. But basically, they don't just get to decide what cases come before them. They can't just say, "Oh, I want to go back and review Roe v. Wade," because there's no active case in which an injury has occurred for them to make a ruling on. They can't just pick up any law that they want and go and review it. So, basically, some case has to come before them that has been affected by some precedent, or there's some appeal against, in which they can make a ruling, and then those items in which those that case itself can be ruled upon, right? And you can question the precedents that were used in those decisions and the decisions made by the other appellate courts, and of course the original district court that put forth that decision. Did I miss anything there, man?
No, the Supreme Court's going to pick up cases. They get to determine what they take, um, which is why a petition for writ, even from your federal courts of appeals, they have to petition for the Supreme Court to take it. There's only a couple of types of cases that go to the Supreme Court as of right, which would be like well, I'm thinking more North Carolina here, but some of your death penalty cases and things like that get higher priority to go up. This particular case that we're talking about that was leaked out was about a Mississippi law that limited abortions before or up to 15 weeks or before. And there was a lady involved who either wanted an abortion or and was denied on the basis of that law. So they use her as essentially the Trojan horse to get Roe v. Wade reviewed by the Supreme Court.
Understood. So there's some conversation around that Roe v. Wade wasn't actually about abortion, that it comes down to the Fourth Amendment and a right to privacy between a doctor and their patient. And therefore, if that right to privacy exists, then the government would never know about it in the first place. There's a lot of Can you sort of explain to us what Roe v. Wade actually is from a legal perspective and what its legal basis? I know it's a complex, but just if you had to boil it down into like two paragraphs, what's it really about, and what was it founded on?
It's kind of the opposite of Roe v. Wade was about abortion, plain and simple. That's what it was about. But what they used to reason that you had the right to get one was this right to privacy and right to self-determination in terms of medical decisions that people, specifically females would get to make, and that the government could only interfere in that decision at a particular point. And that point in Roe v. Wade was the point of viability of the fetus, because the general rationale was this: that the country or the state, the community as a whole, has an interest in the value of potential human life. You never know if the age-old argument, you don't know if you just aborted the guy who cures cancer. Okay.
Mm-hmm.
So that's the societal interest, and you weigh that against the interest of the person. And what the Supreme Court did in Roe v. Wade was basically come back and say, look, there is a right to privacy in your medical decisions, and this is a personal decision. You can view life kind of how you want, and but at the same time, recognizing that society has an interest, we're going to draw a line right here that says, past this point, the states can limit abortions past this point, but not before. Once the fetus is viable, there's no, once the fetus is viable, the state can limit abortions, but not before.
Okay,
And
understood.
so they're basically weighing interests of the people as this amorphous entity, the people versus the person.
Mhm. Understood. Understood. All right. So in the so the question was how. Okay, so one of my viewers is like, how does the leaked document fit into the timeline of the process? How long is the Supreme Court allowed to review cases? Do they have a deadline? Can they take as long as they want? And are they required to render a decision? I interpreted that a little bit to take away to make it a better question. I apologize.
They're going to render a decision. Um, Typically, their decisions are issued a couple of months after the oral arguments. Um, Drafts are just that, they're drafts. It's going to undergo changes. Um, so it's what you're seeing now is unlikely to be the exact wording of what you see when the opinion is released. Um, the court could do something called a per curiam opinion, which basically means that nobody claims authorship of it, but the court agrees on it. So that would be, to me, that would be the obvious thing to do if you're facing a lot of political and social backlash, would be to release a per curiam opinion so that it's, that animus, whichever side it comes from, is diffused across the entire court and not directed at a specific author.
Understood. Understood.
But do they have to decide a case?
They can make a
Yes.
decision saying that this needs further review by the lower court, and basically they're not
Correct.
making a decision, but they're sort of saying you need to go review this and make a better decision, right? Like they can do things such as
Right.
that.
Yes, and they'll say that they'll say something like vacated and remanded for further findings. Yeah, for instance, in your uh, Fisher v. University of Texas, Austin, which was an affirmative action case, that's precisely what they did. Was they vacated this decision and sent it back to the federal district court for additional findings. So it's basically saying we're not. That's their way of saying, tongue in cheek, we're not saying you're wrong.
But you're right.
We're just saying that you need to go back and justify it in a different way. So fix your opinion. Now, sometimes, depending on the language they use in the opinion, they may be saying, we're going to remand it for additional findings consistent with this opinion, which is a strong hint from the court that you may have gotten it wrong and you need to rethink what you thought about.
Yeah. Understood. Understood. So the real question. So if you don't mind, you've had a chance to read the draft opinion, right? And I understand it's a draft. But have you had a chance to sort of read through it yet?
So the draft opinion is about 97 pages. Um, and I imagine that I'm about 38 pages into it.
Well,
And for those of you that aren't familiar with legal reading, and Alex, you've done a fair amount of it.
a little
Um,
bit, a little bit.
yeah, 38 pages of Supreme Court reading with footnotes and stuff takes you a bit. It's
Cool.
legal reading is not fast, not until you get really really good at it.
Yeah.
So you're a 97-page opinion. You're looking at something that's probably going to take about 3 or 4 hours to read in total. Um, I've read the synopsis, what they call the syllabus, basically.
Yeah. Well, my real
Um,
question is what is sort of the legal argument that they're making as to why this is the wrong vehicle, or for why it was not really good case law to have as such a heavy precedent as the basis of other things? That's really the question I'm getting at. Do you feel you have an understanding of where they're sort of coming from on
oh
that?
yeah, yeah. They're going through the part I'm going through right now is a lot of discussion, a lot of historical discussion on fundamental rights, the 14th Amendment, some discussion on privileges and immunities, but mainly confined to due process and whether this is such an important such an important right that it's deeply rooted in our nation's tradition and history. Um, Basically, the general gist of it is they are saying, in essence, Roe v. Wade was wrong. It was poorly reasoned, um, and we don't think it can stand any longer, and we're going to send this power to decide abortion rights and what, whether they're allowed, not allowed, and at what stage. We're just going to send it back to the states to let them decide.
And that really goes back to a statist argument, right? That something that's this. So if you talk to 7 people about abortion, you're probably going to get 7 different answers of what they feel should or should not be allowed, right? For the most part, unless you're talking to a specific group that has specific views, you're probably going to get 7 different answers. And instances like that, there is legal standing that most of the time the Constitution on something that has this much personal interest, right, to an individual should be left to the states, because the states can make up their own, and people can be represented by the state that they in which they choose to live if it's that big of an issue to them.
Correct, and I think that's what the practical effect of this is going to be. I think it's important to recognize that if this draft opinion and its rationale ends up being what does come out and becomes controlling, then what you're looking at is essentially the state by state allowing whatever they want. So if you don't like what your state's policies are, go to California, go to New York. Those
Washington,
states have much
Oregon.
more liberal policies than, say, someplace like Georgia, Alabama, or Mississippi. Um,
Absolutely.
and that's what they call the Supreme Court calls the great social experiment. That each, they kind of sit back and watch and see how the states decide things, and they watch how these laws affect different states and people. And one of the commentaries that Justice Alito makes in the draft opinion is that, at the time of Roe v. Wade, 30 states still outlawed abortion in total. So the majority of states still outlawed it. And if you read a lot of Supreme Court case law, if you see a majority of states doing something, the Supreme Court's not going to upset that. If there's 30 states that say legalize marijuana at some point and it goes up to the Supreme Court, I think what you'll see is the Supreme Court sign off on that and say, there's the more states than not legalize this. It's working out fine for them. There's really no reason for us to continue to endorse the illegality of this when so much of the population is okay with it. And they're calling that out in the Roe v. Wade opinion. Justice Alito is, and saying they made this opinion regardless of what the majority of the country was doing. And it is such a blatant exercise of judicial policy making and judicial lawmaking that it's not consistent with the Supreme Court's function in our government.
What does that mean?
So the Supreme Court, if you go back to,
I know I'm asking some dumb
early days
questions
of our
because I
country,
know I know this answer, but most other people don't. So
if
I
you go back to the
apologize.
early days of our country, there's some cases that talk about what the role of the Supreme Court is. It is the role of the Supreme Court to declare what the law is. Okay. But that doesn't mean that they get to make law. They don't get to make up new stuff. They get to decide if something is constitutional and whether it's enforceable under the Constitution, but they don't get to make up new rules, because
So
that's lawmaking. That
yeah,
should come from the Congress or from the state General Assembly, not from the courts. So the tension in Roe v. Wade was, or the main criticism of Roe v. Wade is that they've essentially made law in the Supreme Court instead of simply determining what the law is and whether it was constitutional, which was their function. And that's what this opinion is really calling out. And quite frankly, Alex, a lot of it has to do with the fact that you've got a different makeup on the Supreme Court than you did at the time Roe v. Wade was decided. During the 50s, 60s,
Well,
70s, and
I think the social
40s.
fabric of America and the social viewpoint of America is also different.
Sure.
America is much more accepting of abortion overall, whereas a majority of states, if they had the ability at the time Roe v. Wade was decided, would have outlawed it. So I think that the Supreme Court saw a need for preserving a woman's ability to choose, because if not, there would have been no room in modern culture for that. But that may not be the case today. And usually changes over time, such as there's a lot of legal precedents, such as precedents that was used in the determination around vaccines, for instance, that actually originated from eugenics eugenics decisions,
Right.
believe it or not, and no one pointed that out for some reason. But
Well,
the
you think
I
about your right to
yeah,
reproductive,
yeah,
your right to reproduction in general came out of a 1937 case where Oklahoma is trying to sterilize inmates to reduce criminals in their population.
yeah.
Yeah,
So
as a way, and that's eugenics.
so as the moral fabric of America changes, the reason that drives the Supreme Court may change, because back when Roe v. Wade was decided, I personally feel that Roe v. Wade was an appropriate decision. Okay? I disagree inherently in my personal beliefs, as most of you guys know, with abortion. All right? But I believe at the time it was an appropriate decision. But I think as of today, with modern society, it is the wrong vehicle of delivery for what it is trying to achieve. And now that the social fabric has become more open, allowing that would allow states to choose these things without severe political repercussions, where no one would ever allow it beforehand, like it was back in the day. I think that that's changed, and I think that that may be a reason for when you don't go with stare decisis, when you see that there was a clear cut original purpose as to why the Supreme Court may have found this way, given the moral and social makeup and the social fabric of America at the time versus today. Um,
Yes, and I think there's a overall we're less conservative in our views towards abortion. I think there's a lot more tolerance of those types of decisions in personal relationships. There's still a lot of criticism of it, um,
mhm,
right or wrong, and so I think what this opinion really does, from a legal standpoint, is calls out Roe v. Wade for for being an exercise of judicial, an overstep of judicial authority.
mhm,
But if you look at what Roe v. Wade was rationed on, and what they really started to hit at were the number of women who were getting basement abortions, going to Mexico to get abortions, suffering a lot of medical consequences from these non-sanctioned abortions, non-regulated abortions, and it was dangerous to women, and it was basically driving women underground, um, to have these abortions, and they made a value determination at that time, essentially, that this was such a great social ill, that we need to figure out a way to make this available to people, so that we don't have this other social harm, which is you know women who are getting these backroom abortions and dying, women who are getting abortions without telling their husbands because it's not legal. So they directed that towards a social ill, but the Supreme Court opinion that I'm reading so far is well reasoned. I mean, in terms of logic, whether you agree with the ultimate determination or not, it is a well thought out opinion.
So really quickly to sort of express to you guys, the thing is that it's since it's supposed to be apolitical, it's looking at the law, right? So for example, there's a lot of questions like myself where I worked for law firms, specifically in North Carolina with what's called the Rowan County Bar, and I've worked with them either directly or indirectly. But the thing is that I asked a lawyer that I know that I worked for directly, how he could stomach representing some of the people he represents, right? And he said to me, he's like, Alex, I may hate them as a person, he said, but everybody deserves the right to representation. no matter what they're accused of, right? And he said, because if not, how can you guarantee that someone's actually getting a fair shot if you just find them guilty because they're accused of something and they can't get a decent lawyer to represent them because not all lawyers are created equal? Then what type of legal system do we have, right? And I disagree politically with this man on many levels, but I have great respect for this individual. Um, and as people know, I have my own legal issues that are ongoing that we don't talk about in depth and I don't give statements on. But it reasons to me because I've seen the prejudice of society against people who are just accused. And though a legal idea or concept may be unpopular, right? It's still, they're making findings of law, not of morality. Okay. And it's whether or not something is good constitutionally, whether something is good from a decision, whether the evidence was there, things like that. Those are important ideas. Um, I just lost you, my dude. I don't know if that was on purpose or not, but it's not about, this is not going to ban abortion. That's not what Roe v. Wade only regulated the first trimester. Okay. And it's whether or not that was a sound legal decision. Hi, Fifth Ace. Good to see you. So I don't know. I it's appropriate for them to, sometimes people are going to make decisions, whether it's to represent someone you don't agree with, or a judge is going to make a decision you don't agree with, but it's about fairness in the law and interpreting the law correctly and constitutionally. And sometimes those opinions are going to be wildly unpopular with the American public. And though they try to shy away from that, it sometimes happens. So, did I lose you, my man? All right, we lost him for a second. So, guys, what we're going to do is we're going to be right back really quickly. I am going to go use the restroom. I apologize. I've been in the hospital all day with my son. I will be right back, and we will get right back into this. We're taking a quick break, my man.
Sounds good. My feed just cut out all of a sudden. I'm not really sure what happened.
All right, we're back. He will let me know when he's back. Oh, he's back. All right. So I was just talking about people have a right to representation in that legal decisions, whether it's on representing someone or a decision about laws and their constitutionality, though they may be wildly unpopular, they're necessary because our law is not supposed to be biased in politics. And so we need to sort of separate ourselves emotionally, because emotionally, though we may find something abominable or we may disagree with it, the real question for the Supreme Court is not about emotions. It's not about social fabric. It's not about those things. It's about, is this a constitutional law? Was the law fairly implemented, and is it correct? Right. No matter what type of case, whether it's a case of an appeal of a death sentence or other things like that, was it constitutionally correct? Was the law implemented correctly? And was the court correct in its findings? Right. That's all that matters. It's not an emotional decision. So
No, and we ought to be able to question previous decisions if they're showing that they're unworkable. Yeah, that's a lot of what you're seeing in this decision is that, they're going back and going, look, this is a huge social issue. We shouldn't have waded into it. It's not really our function. We need to back out of it because it's continuing to come up. I mean, the abortion debate rages. Nothing has settled about it. In fact, it's gotten worse, if anything. Um, so they're basically saying, this needs to be debated among people more in the states, and the social situation needs to be more settled.
yeah, and makes it more of a personalized decision per state than a broad, because guys, federal decisions affect all states, right? So no matter how you view something, you can't move to somewhere else other than another country to find a place that agrees with your personal standings, which removes personal autonomy. And that's a big
Mhm.
core piece. And the ability for self determination is a big part of what America was founded on. That I should be able to make choices for me and for my family, right? Independently of the government. And that I should be able to have some haven that supports those views as long as they're commonly shared amongst a group of people, even if we're in the minority, as long as they exist and they're not abhorrent, unconstitutional. And so I think that a lot of the mainstream media, guys, is really tearing this out of frame. Roe v. Wade does not ban abortions. Roe v. Wade only regulated the first trimester, period. Right? So that's the only thing it regulated. It said you cannot ban abortions during the first trimester. Everything else was open season. This no matter what you hear on CNN or MSNBC, this isn't banning abortion, right? And no matter what you see on Fox News, this isn't going to open the floodgates for banning of abortion across the United States. That's never going to happen on either side, right? This is not going to allow them to ban Roe v. Wade. I mean, the overturning of Roe v. Wade is not going to allow them to ban abortion. You will have the ability to have access to abortion services in America, whether I disagree with them or anyone else disagrees with them, because there are states that have a moral leaning and a makeup of people who agree with the idea and concept of it being allowed. Now, could it theoretically possibly happen? Yes, but it would require every state to have a makeup of a majority of people who have control of enough districts to send their entire lawmaking body into uh, a pro-choice majority. That's not going to happen. That's why our system is set up the way it is. Like people talking about doing away with the electoral college. The electoral college serves a purpose. And you know what's the craziest thing? The people who want to protect the rights of minorities are the people who are arguing against, who say they want to protect the rights of minorities, are the people saying they want to get rid of the electoral college. The electoral college is meant to make sure that just because your state is smaller, you still have an equivalent say, or at least a close enough say, right? It is based somewhat off of population, but you are represented, and you're represented. The Senate, people talking about the Senate should only have senators that are equivalent to the population. No, that's what the Congress does. The Senate is meant to make sure that the majority does not overrule the minority. We are not a pure democracy. Pure democracy is mob rule. We are a constitutional republic, and in a constitutional republic, even things where a minority is represented, they should have some way to have their opinion represented in their government. Period. It's very simple. At least that's my opinion. That's my take on it. Some of those were facts. Two sentences that were opinions, but you can feel free to expound. I just think this has a really chilling effect. The whole point of this leak was to try to apply political pressure to a non-political body that was making a decision on the constitutionality. And if you read it, there is the legal. So I've read the entire opinion, Matt, right? And I've looked up the
Mhm.
cases and other legal philosophies that they cite, and gotten some understanding of some really deep-rooted legal concepts and philosophies that Alito is sort of based. Alito and the other justices that are in the Yay are sort of basing their legal concepts, and it's legal foundationally. the legal foundation of it is there. It is solid. It's not. It does not seem to be a political move.
It's
It
not.
has solid legal foundations, and it seems that there is a group of people trying to make an exceptionally big deal out of this politically on both sides. And this isn't a political decision, in my opinion.
No, it's well reasoned. Yeah, whether you agree with it or not. Um, what I've read of it, he does a very thorough job going into the history of the country, the history of abortion and its practices, you know, before this country was even formed, and it goes back to some of the earliest legal commentary in our country,
Mhm.
um, and it talks about physicians. If a physician gave a chemical or a medicine to a woman with to abort the fetus, then the physician was guilty of murder. And if the woman happened to die from a side effect, he was guilty of murder twice. So these are, when they're talking about there's no specific right to abortion. That's a very originalist view of the Constitution.
Mhm.
And different members of the court at different times have interpreted more into this idea of the Constitution and what it covers, and they call that penumbras, or
Mhm.
things that are implied but not stated. The court that you have right now is more originalist, and they're going to look at the Constitution as a document and go, I don't see that written anywhere. And they're going to look at the surrounding history of the law and the amendment that they're citing for support of abortions, and they're going to look at whether history and the common law really does support that position. And what Justice Alito did was a very, very thorough review of common law sources, articles
Mhm.
from from the
All the way back
founding of
from
this
England.
country.
Yeah. The original
I
English
mean,
law. I was going to talk about that. He actually cites some things in common law that don't have a lot of
mhm.
precedence because they haven't been tried in American courts very often. I mean, there's a few cases here and there, but most of it's based still on English. Like he goes all the way back to the English common law. It's quite interesting how in depth he went for this ruling, because he
Well,
really
I mean,
didn't have to.
I think maybe they understood the impact that this was going to have, and so they did a really good job with the rationale. And he's not. I can't find any fault in his reasoning,
Mhm.
and I'd like to, because quite frankly, Justice Alito is probably the member of the court with whom I disagree the most. I mean,
Cool. Understood.
you know, Justice Ginsburg, I disagreed with in a variety of areas. There were areas I thought she was very sharp. Um, in the criminal law, I thought she was exceptionally sharp. And but this court that you've got now, Justice Thomas, who is an originalist, has a lot of sway. He's a senior member of the court now, and he has a lot of sway over these other justices, especially the younger ones.
Mhm.
And Alito and Thomas seem to view the Constitution in a similar way,
Cool.
which is that it says what it says and it doesn't say what it doesn't say.
Yeah. So we're gonna address another, but really quickly, I want to get to Elscat. So she says her only concern in this whole debate is for women like me who had a child from rape, that what will happen to them if they do not want to keep the child. So I want to reiterate, and I know you're probably just tuning in now because you haven't been very active in chat, and you usually are if you're here. Abortion, overturning Roe v. Wade does not ban abortion. Period. There will always be states in the United States that you will be able to receive, that you'll be able to get abortive services, right? And even if your law, like Louisiana, talking about, oh, we're going to charge people who go to another state to with murder if they go and get an abortion. The first case that comes before the superior, it probably won't even make it to the Supreme Court. Okay, it is clear in how states' jurisdictions work. It is well founded in case doctrine and is enshrined in case doctrine and in the Constitution itself and some of the things we operate from. No state can charge you with a crime that did not occur in their jurisdiction. You cannot be prosecuted in California for a crime that happened in North Carolina. It's why extradition between states exists, and there is doctrine around the ability of a state to prosecute on behalf of another state, which is they can't. Period. It's well-founded law. Like, I don't
Well,
need to make a disclaimer for that. Go ahead,
that's
sorry.
about as well reasoned as people saying, well, we need to legalize abortion at the congressional level. Well, the
Hmm.
Congress doesn't have any authority constitutionally to
And that's what I
legalize
was about to
abortion.
get to. So one thing people don't really understand is that a lot of the laws that we have today come from an extension of what's called interstate commerce law. It's a really convoluted form of law. It people specialize in it. They spend 20, 30 years practicing just that, and they sometimes end up on very vague or very unwell defined law within it that is just difficult. It's exceptionally, these lawyers are really expensive, okay, and they're rare. Um, we're not, yeah,
Well, the area is
we
complex.
know, we've talked about this, but
Yeah, I mean it's
um,
complex.
but guys, example, the ACA, the Affordable Care Act, right, is based on this idea of regulating interstate commerce. Okay, a lot of the laws that we have are based on extensions from something that's not written. There's some interpretation that has allowed them to extend to be able to create laws around it. The federal government was originally only supposed to create laws about things that it was given the constitutional authority to do so. And over time, those issues it has been given the ability to create laws around have extended and extended and extended beyond the scope of what traditionalists or people who are literalists of the Constitution see there, right? And so the shift in the court is not a bad thing, because we've had extensionism for a very long time that has allowed the federal government to extend beyond its original mandate given to it in the Constitution. The states were supposed to decide anything that was not in the Constitution, right? But they were not to violate that. You can add to but not take away from. So you can't take away from someone's constitutional rights, but you can add to them. Okay? And so the states were supposed to make those decisions. It was not supposed to, the federal government was not supposed to be the primary regulatory body of the United States. Period. It was never the intention, no matter how you read it, and even modernists agree with this principle in its initial foundation. They say it may have changed over time because of how, Jefferson saw that the Constitution would be rewritten originally, but was disagreed with the forefathers. There's that whole conversation is normal. The original whole precept is the federal government was never supposed to create laws or regulation outside of its a constitutional authority directly assigned to it. Period. And that's just
The Civil War, Alex.
exactly.
The Civil War. That's where Rehnquist talks about it. That's where everything kind of goes flip flops. You have
Mhm.
a prior to the Civil War, you have a very strong state system with a limited federal government. Afterwards, you have the opposite, and even the Supreme Court justices, right after the Civil War, with some of the laws being made, said things like, surely you can't be serious. You know, they were serious, and they definitely weren't called
Doretto,
surely in
yep.
those days. But he talked about how that represented a fundamental shift, and they
Hmm.
did that as a way both to punish the South, but also to prevent the South from trying to end around uh, the constitutional rights of newly freed peoples,
Such
which
as Jim
was
Crow.
right. So they had to be a bit heavy handed in order to avoid that. But what it allowed, the 14th Amendment, this is what people who are states' rights activists forget. The 10th Amendment reserves rights to the states, right? The
Hmm.
14th Amendment modifies the 10th in those areas. And it basically infringes on the states' rights area. And that's what happened after the Civil War, and that's why you've seen this really expansionist federal power. And we've gotten to the point where the federal government has its fingers and tentacles in a lot of things that constitutionally it probably shouldn't.
Agreed, agreed. All right, guys, before we move on to the next subject, because we do have to get moving on from this, this is great. I appreciate all of you. We're going to read the comments real quick, but make sure you guys like and subscribe this video. Leave a comment whether you disagree. If you dislike this video, dislike it. Make sure you leave a comment. If you have any questions, I'll try to follow up. But we do need to move on at some point. We're going to comment. We're going to cover the comments really quickly. Um, so Jim W says, if a female has been raped, should she be able to whatever the hell she wants without having to ask? So here's the thing. that's not a legal question. Okay, that doesn't have to do with Roe v. Wade. That is a moral question that is left up to the states and to the people of those states if Roe v. Wade is overturned. And even if Roe v. Wade wasn't overturned past the first trimester, that's still left up to the states, guys. That's a separate subject, and this is where I get into where we start talking about whataboutism. When we're talking about Roe v. Wade, people try to bring up these appeals to emotion. My personal opinion is abortions from rape make up, and I linked it in our Discord, and all the sources are available there for what I'm about to talk about. Okay, so I don't get banned off YouTube. But less than 0.5% of all rapes, okay, of all abortions are about people who have been raped. Okay, if we can agree, and 1% is from people of victims of incest or risk to the mother's life. If we can agree that all other abortions are up for grabs, and the federal government wants to rule on that very specific thing, we can have that discussion. But first, we need to agree that the other 98.5% of 98.5% of abortions are up to the states. If we can agree to that, we can have that discussion. But that is a separate discussion and has nothing to do with Roe v. Wade. And this is where I'm getting. The media is hyping this up as, oh, well, women will be forced. And if you have, guys, I want to be clear on something else. It was brought up, and I had to go. I went to Justia, Westlaw, and LexisNexis last night, and I researched this in depth. I cannot find one case in which a woman has been prosecuted, all right, for a miscarriage. The only time a woman has been prosecuted for a miscarriage is where it was clear and made out that that person intentionally induced their miscarriage because they could not get an abortion in their state. And there's only 2 of them since 1961. Right, technically 1983 when they started digitally tracking all of this, but LexisNexis actually has case doctrine around quite a bit of cases all the way back to 1961. There's only 2 cases, and in both of those cases, the person admitted to it openly in a written fashion or through it actually saying, "Yeah, I did that." Right, and those are the 2 cases in which a miscarriage has been prosecuted. No other times. It is, you can't prosecute someone for a miscarriage. It's not their fault. There's this, even manslaughter requires some form of intentional action, guys. There's no case for murder there. The statute doesn't support it. When you have a statute, there are elements of a statute that have to be met in order for a crime to have been committed, right? In most, I can't speak for all states. This is, again, not a lawyer, not a legal professional in any way, but in every statute that I've seen, it requires some form of intentional act, whether the intent of that act was to kill or to harm someone, right? It requires some intentional act on your part in order for you to qualify for those statutes. I haven't found one that doesn't require that. So you're not going to get charged for murder or manslaughter for a miscarriage. It's not going to happen. It's just not legally there. The statutes are
Not an
not structured.
accidental miscarriage anyway.
Yeah, not an accidental miscarriage. Let me be clear. Accidental miscarriage. Yeah.
Now, the common law is full of cases where women were charged and convicted of murder for, yeah, for seeking abortions.
But
But that's
no
you're
state has
talking.
no state has common law abortion laws anymore or miscarriage laws anymore. They have all created regulation around this. Every state has some form of regulation around abortion and what is considered an accidental death or miscarriage. Because when there's no law specifically around miscarriage, they fall back to accidental death, right? And intent is a big deal there, but and negligence. But we're not gonna dive into that. That's far beyond that. So,
That could be its own podcast.
that could definitely be its own podcast, guys. What we're talking about, there are deep legal issues here, and we're sort of given the 10,000-foot level. And when you see me and him dodge on a conversation like that, that's because that, as he said, that could be its own podcast. Absolutely. Um, let's see the Vicky White. I don't see a Vicky White, but yo, what's up? Oh yeah, let's move on to Vicky White. So Vicky White, guys, we were talking about this the other night. This is the lady who Casey White, they were not related to each other, helped escape from prison and went on a run. And we were talking about this, and I think it was either Jim or the doc who were asking, could it be, what is felony murder rule? Could felony murder rule apply to Casey White because of Vicky White's death? And other things like that. Now, this does vary from state to state, so we're going to be talking about North Carolina law mostly here, unless um, Matt has a further understanding of federal law. Federal law is a different practice than state law, and it requires a different bar certification with the federal bar. All right. So tonight, most of what we may talk about may apply mostly to North Carolina, unless Matt says otherwise. Okay. But we're gonna talk about the felony murder rule, what it means, how it applies, and that's gonna be kind of our final topic. Um, wasn't there a movie? No, this literally just happened, Elscat. There's no movie about it yet. All right, so basically,
Probably
Vicky
should
White.
be.
Yeah, there should be definitely. This is a rare occurrence. So basically, Vicky White helped an inmate that she fell in love with, apparently, to escape prison. They went on the run. They got caught, and Vicky White, when they were getting caught, decided that she was going to end her own life and shot herself, from what we understand. Um, there's this idea. So when you break out of prison and you run from the cops while being broken out of prison here in North Carolina, and I'm pretty sure federally too, that's a felony. All right. So there's this idea called the felony murder rule, and that's if any death that occurs in the commission of a felony, right, is can you can be charged for first degree murder. And I'll let Matt sort of cover that more in depth and explain better because I did a poor job there. So Matt, what is the felony murder rule, and how what does it sort of cover?
So you got to remember the felony murder rule is about something called foreseeability.
Mhm.
Okay. Certain types of crimes, and the felony murder rule really comes out of the common law where certain types of crimes were considered they're violent by nature,
Mhm.
and so it's foreseeable that somebody could get hurt or killed. A a rape, as was mentioned in our previous discussion, is considered a violent act. In fact, it was a capital offense. Probably may actually still be a capital offense, though the death penalty is never imposed for it. So, breaking and entering into someone's home can be considered one. Robbery from the person, robbery. Um, and what you're seeing with a lot of these overdose death laws are also based on felony murder. This, Alex, this was actually a bar question
Mhm.
on my bar, as to whether somebody who sold drugs could be prosecuted.
In North Carolina, sale of cocaine is actually considered a violent crime.
Well, at this point in time, it wasn't.
Okay.
But my argument in the bar exam was that when you're talking about the sale of narcotics, overdoses are a known risk, as are violent crimes. And so it's just as foreseeable that someone could overdose and die from your sale of narcotics or be involved in a violent act leading to their death as it is in a break or enter or escape from prison or
Hmm.
something along those lines. These are known risks with this type
Hmm.
of behavior. And that's really what the felony murder rule is about. It's about punishing engaging in violent and dangerous behavior. And so, what it allows you to do is it allows you to take people who ordinarily may not be responsible for somebody else's death and hold them responsible for that person's death. Now, Vicky White's case is a bit interesting, though, isn't
Yeah, give me 1 second. Can you get me real quick? Do you have Lexus available? I don't want to pull it up on my screen because I could get in trouble from LexisNexis. Can you give me the statute for sale cocaine, North Carolina?
it's under 9095. I think it's under 9095A. Give me just a
Uh,
second, and I'll pull it.
cool. Appreciate it. I just want to show you guys something that's insanely crazy. So we went to go expunge one of my friends who got a cocaine charge, sale of cocaine charge, when
Yep,
he
can't do
was a
that.
juvenile. When he was a juvenile. Uh, and the thing is that so there's like some things where you can get like a single charge if you never had another drug charge, other things expunged. I was working with a lawyer on this. I don't remember the exact details around the case, but because sale of cocaine is considered a violent crime, the expunction was not allowed to reinstate his gun rights. So No, I won't get in trouble. I didn't give the person's name. I didn't state anything about them that was personally identifiable. I can talk about the generality of a case as long as I don't break that person's confidentiality in a way in which they could be identified.
So it is a, I don't think we ever do this here. We don't, I don't see it charged much, but it's actually, um, it's 9095A2
Mm-hmm.
is the sale as to manufacture, sell, or deliver, or possess with intent to manufacture, sell, or deliver a controlled substance. And then B1 classifies Schedule 1 or 2. Cocaine fits in Schedule 2 as a stimulant, and a one that has a limited medical usage.
Mm-hmm.
It is the sale of cocaine or heroin is going to be a Class G felony, so your maximum possible penalty for that would be 47 months if you had a terrible criminal record.
Mm-hmm.
And so that's the basic for
Yeah.
that.
So, anyways, but stuff like that, where a statute, where in and of itself a crime may not be considered violent in and of its nature, but under the statute itself, if a conviction, it says that it is considered a violent crime, it's a violent crime. It doesn't matter if it's not involving actual physical violence. If the statute says this is to be considered a violent crime, that's what you got.
Well, and a lot of these, especially you're talking about the sale of cocaine and methamphetamine, you're talking about an enterprise that's inherently dangerous because you're
Mm-hmm.
talking about drugs that impair thinking,
Yep. And right back to what you were talking
money.
about. Yep.
Yeah, and so again, you're going back to foreseeability of harm. You know, if you walk, let's say for instance, you commit a felony of, now let's try simple possession of a
Mm-hmm.
controlled substance for or possession of drug paraphernalia, and it's your paraphernalia. Is it foreseeable that somebody else's death is going to occur from your usage of a controlled substance? Not really. You know, there's always the outlying risk that you could, you know, if you're using meth, you could have a really bad trip, you could start hallucinating and go unhinged and cause havoc, but that's a bit more speculative. When you're talking about things like robbery, breaking and entering, um, drug trafficking, you know, rape, these are all things, you know, these are all things where the risk of, you know, significant harm to an individual is high.
Mm-hmm. Yep. No, understood. And the interesting thing for her is she never officially retired, right? And one of the aggravating factors for murder to make it a capital punishment is that it be an officer of the law or a corrections officer, if I'm not mistaken. Um, so it's going to be interesting to see if they charge, because there's already been talk in the prosecute. Why can't I think of the group of prosecutors? They call themselves something. Why can't I think of it? Really. So North Carolina basically has this group of prosecutors, right?
Oh,
And
you talk
they,
about the Conference of District
yeah,
Attorneys?
Conference of District Attorneys. So Conference of District Attorneys, there's already been talk on their boards. Basically, we're not going to get into what listservs are and stuff like that, but basically on their boards there's been talk about whether or not he could be culpable for felony murder charge, considering that it could be foreseeable that the act of breaking out of prison is, one, a felony, and two, is could have violent outcomes, right? That it's foreseeable that there could be a loss of life from this act. Even though she willingly partook, there have been people who have been charged with felony murder because of the death of their co-defendants during an act, right? What would have been their co-defendants? The person's dead; they can't be charged. So it's quite an interesting case, Matt, because the question was asked. Well, we were talking. I said I think it's possible that you could extend the felony murder rule. What's your take on that? Oh, that was another one. We'll talk
I
about
think
that.
it's a
The other
stretch.
argument was, question people had was, she took her own life. Does that matter? There are
Yes,
people
to
who've
me,
had heart attacks
I
during
think that's
bank
a critical
robberies.
distinction.
Good, sorry. Cool.
I think that's the critical distinction.
Mm-hmm.
You know, in all of your felony murder, you know, analysis, you're dealing with, you know, your the foreseeable consequences of your own action. You know, the fact that she decided to commit suicide is really a supervening event in my view.
Okay.
Yeah, that's an individual choice that she made that's not necessarily foreseeable. Now, if he had some specific knowledge that this was her plan, if they got caught, yeah, I think you'd have a stronger case. But at the end of the day, suicide's a very personal choice, and I don't know that it's foreseeable in the same way that you and your let's say you and your buddies decide in a that you need some money for meth, so you decide to go break into some guy's house down the street, steal some of his stuff, and you come in the window and you surprise the homeowner, but he has a 12 gauge shotgun and your buddy bites the big one. So,
Yeah.
that's foreseeable. You go breaking into somebody's house, especially in the South, I mean, that's just not a good, that's a foreseeable event. Somebody gonna
Yeah.
die.
Hmm.
I don't think this is foreseeable in the same way. Now, it may be a little
I
more
forgot about
common
that
in
part.
today's day and age, but I don't think it's foreseeable in the same way.
Yeah, yeah, that would be hard to meet the foreseeability part of that statute. I could see how, because of what I think would be the inherent bias against him as a defendant, right? I could see how a jury could ignore that part of the statute, or just say, it was easily foreseeable someone could get harmed from this. It doesn't matter if he could foresee if it was through her committing suicide because she didn't want to spend the rest of her no her natural life in prison. Um, or not, it was foreseeable someone could possibly die from this. I could see how a jury could extend to that. Just so, guys, there's this idea called jury nullification where a jury can feel that even though it seems that a law was broken, right? That that in this specific circumstances, due to the facts of the case, that this person shouldn't be punished or be found guilty. That's called jury nullification. It's a little bit more complex than that. There's also this idea such as where a jury finds someone guilty even though they don't feel all the facts were met, because they feel that the specific fact pattern, this person is truly guilty of this crime in their view, right? And you don't get to go back and ask. We had a specific case where a man literally defended himself when a defendant came in the door who had been known had cut his uncle from chest to stomach, right? And he used his wife's firearm in defense of his home. Because he was a convicted felon, he was charged with firearm by felon with intent to with assault with a deadly weapon, inflicting serious bodily harm with intent to kill, right? Um, the problem now, they found him guilty of all the parts except that he intended to kill him, right? And with firearm by felon. Now, the only reason that this case was a thing was because he used the term my firearm. And literally right after this case, there was this exigent circumstance instruction that was allowed to juries that didn't exist inside of our court system, but one adjacent to it, because that's how circuits are defined and jury instructions are different. Anyways, but in this circumstance, right, it could be arguable that this guy was justified. It wasn't his firearm. He used it in an exigent circumstance. This man's currently serving 8 years in prison. Had a baby on the way, right? And it's insane. Now, was it legally correct? Yeah, but if they could have convinced a jury that, in this specific given this set of facts, right? It's they have a right to nullification. Um, Based on their opinions, it's possible that he could have gotten out. Now, getting a judge to advise a jury and jury instructions on jury nullification and the idea of jury nullification, it's iffy. I
It's
I didn't.
forbidden.
Yeah. Oh, it's forbidden now. They did
It's
that like
forbidden.
6 years ago.
You cannot argue for or insinuate for jury nullification. It's unethical.
What? Then how did? We'll talk about that case later. There's a specific case I'm thinking of in which it was inferred in closing arguments. So,
Yeah, you're not supposed to. Yeah, you're not supposed to do that.
oh, okay, okay. Well, I was gonna say I've never seen it done, so I don't think that can happen. But this is basically the idea of jury nullification. Um, but juries are a crapshoot, guys. It's why you can be absolutely 100% legally in the right, and you can still go to prison.
Well, Chuck, this isn't the first time this type of thing has happened. If you look at the link I sent you, Alex,
Uh huh.
um, what you'll see is that where I'm from in the mountains, this actually occurred about 13 years ago. There
Where'd you
was a
send that
spring
at, my
camp.
man?
Do what?
Where'd you send that at?
I sent it to yourself.
Oh, okay, okay, okay. Yep. Sorry. Thank you. Go ahead. I'm sorry, Matt. My phone's dead.
There was a Swain County, which is Bryson City. There's also a
Mm-hmm.
federal courthouse in Bryson City, by the way.
Yep. Mm-hmm.
A Swain County jailer assisted an inmate in escaping after they had had a soiree in the local jail for a while. They went on the run. They were ultimately captured. But this does happen on occasion. Now you could really see this. The one with Vicky White was in a larger facility with more control.
Mm-hmm.
Um, Swain County, if you know anything about it, is kind of it's a small county. It's where most of your Qualla boundary exists, the Eastern Cherokee Reservation.
Mm-hmm.
So it's kind of an interesting world out there. It's very. I'm trying to think of the right term. It's still wild. I mean, in a lot of ways. So the jail was small. The number of people were small, so it was easy for her to be able to do these types of things. But this stuff does happen on occasionally. You can look and see North Carolina Department of Corrections, or I'm sorry, Division of Adult Corrections employees get charged with this from time to time, for inappropriate relationships, smuggling drugs in, things like that. It's actually a lot more common than people think.
Yeah. Not breaking someone out though, man. That's not every day.
Breaking someone out's a bit of a step. Yeah, that's a new one. Or, well, it's not really new. It's just not common.
I mean, I want to equivocate where, smuggling and other things, that definitely happens. You know what? Jail staff and prison staff are criminally underpaid guys, but unfortunately that's the nature of our system, which opens them up for corruption, especially when you're dealing with, you guys know that an ounce of marijuana inside of prison or jail can net you as a prisoner that's selling it over $1,000 worth of value. Like it's really lucrative. So, when you're saying,
also
hey,
net you an additional 39 months.
I was getting to that, but for guys serving life, they don't give a shit, right? Because life,
another 39
yeah,
months if you're there.
Life in North Carolina is until you get a toe tag. Okay, there's no limit on it, right? So, that's not. But I don't think we can equivocate. Yeah, I think I think we can't equivocate the two. Honestly, all right, so. So I semi agree with what you're saying. I get it. I see there's a place where a jury could still find them guilty, but I think by statute you're right. But as we know, statutes don't mean much if a jury decides that they just don't give a shit. So,
no, I mean, and innocent people do get convicted.
Yeah,
Alex. I mean,
yeah, we've seen it. We've seen it just in the small time that I spent, practicing with. I don't want to say that other person's practiced without their permission. So, but we've seen it. We've seen instances where we saw people that were clearly guilty just walk, right? And we've seen other times where someone was, most of the time, guys. So the instance I saw, the reason why this guy got convicted was because of his past. He did have a criminal past from the 1980s and the early 90s. All right. Most of the time when you have these types of cases, someone has something in their past that makes the jury look down upon them. So even though they were legally correct, because of how people feel morally about them, it happens. And jury deliberations are entirely private and privileged. Like the judge can't even be privy to them, right? And even if things are, it all depends. There was an instance in which there was a murder case in which a young, promising attorney of the Rowan County Bar, who I have respect for, even though I faced him as an adversary in my civil case, was arguing a murder case in which the jury literally said, well, we don't feel anybody did anything wrong, but, somebody's got to pay for that body. You know the case I'm talking about, I think, Matt.
Mm-hmm.
Yeah. Literally, the jury felt that, hey, it's legally justified, but we just can't let someone be killed like this and not send somebody to prison.
Which is
like
kind of horrific.
Yeah, it's kind of now this is known, but the local Superior Court judge at the time couldn't do anything about it. Why? Because even though it was known that this was said in those jury deliberations, those jury deliberations are sealed. They're not allowed to be discussed, taken into account, nothing, right? So it's just how it stands. All right, so what's up? So it says, yeah, if you get caught with an ounce or two of actual weed, it gets taken away, and they tell you to go home. If you have any oil on you, that's a charge. So, guys, be careful when you talk about decriminalization of marijuana. Okay, a class 3 misdemeanor can still affect you if you ever catch a felony. If you were looking at expungement rules or stuff specific to your state, talk to an attorney. But the best thing is just don't catch those, because decriminalize, it's still a class here in North Carolina. It's still a class 3 misdemeanor, right, Matt? Like simple
It
possession of
is, but if
marijuana.
you do it enough time, you'll spend some time in county.
So, and also, if you ever get a felony and you want to get that felony expunged, one of the limiting factors is if you have previous drug convictions, and those can be class 3 misdemeanors. From what I understand, when we tried to do that as an expunction for a client in a practice I worked for. So, um, be careful. Decriminalize is a tough word. Just like, guys, you guys can go and plead out in traffic court and not realize that what you're pleading to is a misdemeanor. That I learned that from Matt.
I mean, it's still, yeah, it's still a misdemeanor, and I think the big issue, the big thing people miss in traffic court is what DMV is going to do with whatever they plead to.
Or these guys with
Because it's not just
DWIs.
about the judge that you have to fear; it's the Division of Motor Vehicles.
Yeah. So people who are like, "Oh, I'll get my license. I'll get my license back legally," but guess what? The DMV revoked your license on repetitive DWI, and then you're at the mercy of a board. It's so be careful what you talk about. Decriminalize. Decriminalize doesn't always mean. I don't know how else to say it. So, talk to your local attorney. Um, Listen, man, I appreciate you, Matt. You don't have to stick around. I'm going to take some chats and stuff, man. I appreciate your time. Thank you so much for being here and helping
No
us
problem.
understand some advanced
Thanks for
legal
having me.
concepts. Guys, make sure you look him up. Barton and Doomey Law Firm in North Carolina. Um, what do they call? Okay, here's a question really quickly before we go. What do they? Why do they call it DWI versus DUI? What's the difference? Todd told me it's just a different acronym. Unless Matt has something to add to that.
I don't know. The Court of Appeals gets a bit touchy. Um, Driving under the influence is a little bit broader than driving while impaired, because you look at the difference between influence versus impairment. Something can influence your behavior without impairing it to the point where you're unfit to drive. So, so the term has there's a bit of nuance to it. Um, and the jury instructions say while subject to an impairing substance, not just one that influences you, but it has to impair you to the point where you lose the normal control of your mental and physical faculties. So impairment, in my view, is a slightly higher standard. Um, but I think in large part, the public views them the same. So
Yep.
I don't know that there's really much of a practical difference, honestly.
Agreed. And by the way, guys, if you guys are in North Carolina and you're ever interested in talking to an attorney who's really highly specialized in DWI, um, excellent attorney in Salisbury, Davis Jr. He's part of the Davis Law Firm, probably the most amazing DWI attorney I've ever seen. I'm sorry, Matt. I don't mean to. I don't know if you commonly do DWIs, but I don't want to
We
step in.
do them fairly regularly, but uh, Mr. Davis and his dad are really uh, they're as close to an expert in the field as you can get. The state bar doesn't like you to use that particular term.
Yeah, don't
Um,
get yourself in trouble ethically. I just wanted to. Yeah, don't want to.
no, but
Yeah.
I think if you're looking for somebody that knows the ins and outs, and is really understands the area in a way that most attorneys do not, um, he does. He's really, really, really good. And there have been occasions where I've told people, this is, I'm okay with them. I can do them. Um, I understand a fair bit about them because of my past, and so I know what I'm doing.
Matt used to be a cop.
But if you're looking for somebody that understands literally the ins and outs of every argument
Hmm.
and has been through the same schools as all the officers, and can take a stopwatch and a body cam video and just eviscerate an officer on how they administer a field sobriety test, then that's who you want. I mean, everything from the angle of the pin or the light, to the time it takes to go to the outside of the eye and back. Yeah,
Hmm.
he knows all of it.
Yeah, it's another thing. Just like with speeding tickets, guys. Like if you get a civil attorney to do your speeding ticket, so it's one thing to check if the officer had their gun certified, their radar gun certified. It's another to ask if the certifying authority was certified to certify. Swear to God, it's a real thing. And you know, different specialties for. I mean, there's a specialty in civil case, and it's specifically for civil cases in custody. Um, is there one for capital cases, Matt? I don't. Is there a specialty for capital cases in North
I
Carolina?
don't know.
I don't think there
I'm not
is.
sure.
I know there's one for civil. I don't know about the other ones. So
They have criminal, family,
family
appellate.
law. Yep. Yep.
They do. I think they have estate stuff too.
Yep. Cool.
So
Understood.
the standards are all different. I know Mr. Davis Senior in Salisbury has three specializations that he's
Family.
board certified for.
Yep.
Um, yeah, I think it's federal law, federal criminal, state criminal, and family law.
Mm.
He's one of, I think, a handful of people in the state that have that number of certifications.
Cool.
It's a lot of studying. It's a real passion of his. He's a very, very smart man.
Yep.
Very
Absolutely.
dedicated, very hardworking.
Yeah, he may catch a lot of hate, but he's a good lawyer. Both of them are. And
Well,
anyways, all right, guys. But yeah,
means he's
man,
doing his job well.
yeah, I appreciate your time, Matt. Again, I know it's past 9. You're welcome to hang out. We're gonna continue to delve into a few things. I'm gonna take some comments. But I just want to let you know I appreciate you and thank you for bringing your expertise to this conversation because I didn't have the deep legal understanding of some of the questions that are being asked here, and it's greatly appreciated, my man.
Well, I
So.
appreciate you having me, Alex. It's fun to get into intellectual discussions once in a while. The day to day. You remember what the day to day of the law practice is like, and a
Oh,
lot of
yeah.
it's a lot of it's just making sure that you cross T's and dot I's.
Mm-hmm.
So it's not often that we get a chance to do that. I typically don't. It's rare that I get cases where I get to stretch myself intellectually, and that's one thing I do enjoy about the appellate work is that there's a little more freedom intellectually to make arguments.
Are you on the
And
appellate
to
list now?
No, I don't. I've done one criminal appeal. Actually, the majority of my appeals are civil in nature.
What's a list? So, guys, when I talk about a list, so when you're doing state work, right, where it's basically indigent people who don't have money to hire lawyers, there's different lists. There's the district court list, which is for mostly misdemeanor. I don't think district court doesn't handle felonies. Period. It's all misdemeanor work, right? Then you have the basic superior court list, which is lower felonies. You have the capital defenders list, which is capital cases, and I'm sure there's a few more lists, but those are the main ones that I'm aware of. And so when you get on these lists, it means that you'll be assigned cases from the state that are specific to those lists. Go ahead, Matt.
I do appellate work privately. Um, I've got I did two last year, and then I've got one that was returned from the Court of Appeals and probably is going to go up again in the next 2 weeks or so
Oh,
that I'll have to start working on.
can you share any details of that?
Custody case, um, deals with grandparents.
Does it happen to be the
Um,
one that we passed you? That one with the out of state?
no,
Okay, yeah.
mm-mm. No, this is one that came from another firm that represented the other parent,
Ah, yeah.
and the parent that I represent needed somebody for the appeal. It actually got a bit complicated for a while,
Mm-hmm.
just with how to get the Court of Appeals to take her arguments,
Uh huh.
um, because you know, there wasn't a direct appeal taken from the judgment. So my client was a party to the appeal, but the appellate rules limit the types of arguments that you can make if you didn't appeal the judgment yourself. So there's another procedure that you have to go through to see if the appellate court will let you make additional arguments. And essentially, you have to ask the appellate court for a writ of certiorari for yourself or for your client, so that you can make the types of arguments that you need to make if they're different than other parties' arguments. And
And that
that's
certiorari,
what
Rory, that's the one we were talking about where they can take up something
mhm.
they normally wouldn't be able to take up, just to be clear for
It's a
everybody.
discretionary writ, which means they can
Hmm.
say yes or no.
Yep.
But you got to get their and just like with the Supreme Court, you got to get their attention. It's got to be something that they want to address.
So sometimes there's gaps in the laws, or there's there's case law that hasn't been established, and though you may not normally have a grounds for appeal under what's already been established, sometimes because you can show a gap or something that's interesting or interest the inner lawyer inside of a judge, you can get them to take it up in the appellate circuit. So, you know.
And a lot of it has to do with whether there's an individual result that's skewed to the point that when they look at it, they think it's worth correcting. Um, or it's in the case of the North Carolina Supreme Court, they're only going to take it if it involves a fairly substantial question of state law.
Mhm.
So it's something where they feel like there's guidance needed for the legal community and for the lower courts, so they'll take it up because of that, um, and they'll rule on it so that the other courts and attorneys across the state have a guideline kind of on what to do with certain cases. My dad and I argued one in front of the North Carolina Supreme Court about 5 years ago. That was a foreclosure type case. Um, and it was an interesting experience, and the Supreme Court took it, even though my dad had won it in the Court of Appeals. The Supreme Court took it because it involved a fairly substantial uh, question about the statute and how it was to be looked at in the courts. It's an old statute from the Depression that we were dealing with. It's a consumer protection statute, and the Supreme Court felt like it needed to be addressed as to how we were going to, if these arguments were being made in foreclosures and deficiency judgments, then that there needed to be guidance as to how courts would handle this particular issue. So
Well,
that's why they took that.
uh, yeah, Luna, the Slammer in North Carolina is a magazine, quote unquote, magazine published once a week with everyone's mugshot from the week before. How is this not slander or libel? Because that's public record. You got charged with something. You got a mugshot. It's factual, right? They're not
And
saying
it's
you're
true.
convicted. Yeah, it's true. Um,
Truth is
let's
an
see.
absolute defense to slander.
Yep. Uh, Good to know if I catch a charge from my mom being wild on my vacay in North Carolina in a couple of weeks. Yeah, yeah, give him a call. Uh,
Don't get too
um,
wild.
don't get too wild. Absolutely, we would never condone any purposeful and intentional breaking of the law, or unintentional either.
You
Yeah.
Getting wild in Rowan County is probably not the best idea anyway.
Probably not. Probably not. Oh, I heard my favorite DA, and I mean that literally. Tim Cook became your local Superior Court judge.
Tim Gould.
Tim Gould. I mean, I said Cook. I'm
Hmm.
sorry. I
Yeah,
got confused there for that.
he's a very good judge actually.
Absolutely.
In fact,
I've heard
Tim's a
great
very
things
smart
actually.
guy. He's an extremely bright man, and he's actually turned out to be even a better judge than I thought. So he's exceeded expectations. He's very, very good.
I remember me and him became friends on Facebook, and I said, "Hey, man, due to my circumstances with the state, it's probably best that we don't be friends on Facebook." He's like, "Oh shit, I wasn't even." There went him here in my case. Anyways, no, man, I'm really glad, and I understand you guys are starting. Um, your partner, of course, Matt, graded all, and you guys have a multidiscipline practice, but Matt still doing his thing with corporate law and stuff and all that good, all that good stuff. So he's
We don't do
back.
as
He's
much
back
of
in
it as we
action,
used
right?
to.
He's back in
What's that?
action, right? He's back in action though, right?
Hmm?
He,
Yeah, he's Chad's gone a lot. I'm in Rowan more than he is right now.
yeah.
He does a lot in Forsyth.
Well, I remember you said he hurt his back or something like that. I just want to say he's okay though,
Yeah, he
right? Yeah.
did, and then apparently that's communicable because then my back went out. So as I was complaining about him being out with his back, karma decided to pay me a visit, and then I hurt my back lifting, and
Mhm.
so I'm just now to the point where I'm able to really go back to exercising regularly.
Absolutely. Absolutely. Understood. So, man, as I said before, you're welcome to stay. I don't know if you're limited on time. I just keep trying to wrap up because I know I told you till 9, and I don't know, I know
I
you
don't know.
got the
I'm going to see
wifey.
if my wife ordered me any food.
Well, there we go. There we go. But stick around, man, if you're welcome to. Um, the next thing up, guys, that we had on the calendar was there was a very interesting situation that happened um over the weekend. It's a total departure from what we're doing, trying to bring something a little bit lighter towards the end. You guys know this. Um, but basically, they, for the first time ever, grew plants in lunar soil. We're just going to totally change topics here. Like, it's crazy. Let me bring this on down.
It's only because the aliens let us.
Yeah,
Only
sorry. It's interesting.
it is. Oh, there goes my Norwegian brother from another mother and father. What's going on, Holy?
I was here all the time. I just didn't want to interrupt you guys.
Oh no, I appreciate it. I figured that. I saw you at the beginning. Yeah, dude, that's crazy, right? Like, so guys, for the first time, we grew plants in lunar soil. Like, this is like cool stuff. We're doing some sciencey shit for once instead of focused on hating each other. So, yeah. What's that? My friends are in there. I left the scene for a dentist appointment, and they got caught like 20 minutes later. Okay, guys, don't admit to. Okay, don't. That would be giving legal advice. I would say, guys, I would personally never admit to the commission of any crime whatsoever.
But you have an absolute right to
In chat.
keep your mouth shut. It's
Yeah.
always a good idea to exercise that right.
Yeah, and even when you think you're totally in the wrong, and every lawyer you're totally in the right, and every lawyer says you're totally in the right. Remember, cops are not there to care about if you're right. They're there to find somebody to cop with the crime. So, I'm a perfect living example of this. Yeah, just don't talk to the police. Don't talk to the police, guys. There's a perfect YouTube video called "Do Not Talk to the Police." They just don't do it.
Yeah.
It's very simple. That's my personal opinion. I'm not giving you any form of legal advice. Again, consult an attorney.
Found out that in hard way.
And then don't talk to the police.
And then don't talk to the police. Consult an attorney and then don't talk to the police still. If they're even talking to you, guys, by the way, they don't have to read you your Miranda rights if they're just having a conversation with you. From here in North Carolina, at least. Just don't talk to the police.
That's federal. That's a constitutional thing.
Yeah, I thought so. I just didn't want to give legal advice once again. I trade carefully.
Everything you say can be used against you. That's
And
the
will.
law.
And will, absolutely. Covering his eyes with
Sometimes
his
things
hand.
that you don't say.
You said Matt is shaking his head.
Basically, you can
Matt-
talk, just don't incriminate yourself,
Matt covering his eyes with his hand with that one was so good. What? I didn't see that. You cut. Were you judging? Were you over there judging me, Matt?
No, no, it's not my place to judge.
were you over there thinking he needs to shut up? It's okay.
No, I just wish more of my clients would exercise that right.
I know, right? Exactly. Guys, you wouldn't believe how many people would have never been convicted if they just would have shut the fuck up. Like, don't make up stories. Don't do none of that. Like, literally, guilty or not, just don't talk. They tell you, oh, somebody's over in the other room singing. Okay, cool, let them sing. Do not talk. You are in a jail cell with somebody, do not talk. Actually, before you go into jail, if you're turning yourself in, record a video that says, hey, I just want to make it very clear. I know better than to tell anyone the specific details truthfully in my case. So if anyone comes forward saying that I talked to them about my case in jail, it's wrong. Like, do not talk to nobody. If you're in jail, don't possess do not have a copy of your discovery, okay? I'm not going to say why. I don't want to impugn the character of anybody or get myself in trouble, but just understand that someone could open that up and get details of your case that aren't public and then become a credible witness in your case for the state. That's all I'm going to say. Like, just don't talk. Don't possess anything that could give away details of your case. Don't talk about anything, period, to the cops. They're not your friends. And listen, my adoptive father was a Charlotte Mecklenburg police officer for 25 years. I got nothing but respect for most police officers, but they have a job, and most of the time it's at the indirect direction of the DA. Okay, they serve they unfortunately, and that's not their original intention. And most of them have good intentions, but at the end of the day, they have a job to do, and they need to preserve their job to feed their family.
Well, the
So
general rule of thumb is that what you don't say can't come back to bite you in the ass later.
exactly, yeah.
I've got a client now who's probably going to go to prison for a period of time because the case is triable without my
It's
client's statements.
oh
So I
man,
mean, there's there's really good reasons that you just keep your mouth shut.
yeah,
Yeah,
no,
when people
absolutely.
say, "Well, the cops are asking me questions about this," and I didn't feel like I didn't feel like I could say no. What are they going to do? Beat you?
Take you to jail.
Basically, you're not guilty until proved otherwise.
Well, that's not how it works here. And so, also, guys, the assumption of innocence only applies to the state and the federal government. It doesn't apply to anyone else, right? So, example, in my case, when they run a background check and they see that charge for 14-7, or if it's a 14-6, I think it's 14-6. Yeah, 14-6, right? When they see that 14-6, they don't have to presume my innocence. They can just not hire me. Um, the presumption of innocence is only by the state and the federal government, and you can take that how you want.
Well, they call it the new civil death. That Justice Sotomayor's got some good commentary on it. One of the cases that she did a, I can't remember if she did it. I think she did a dissenting opinion on it. She's actually pretty sharp with stuff like that, and she talks about how we treat criminal charges and convictions in society, and
Mm-hmm.
and the effect it has on people.
And actually, there's been some good and positive change, in my opinion, in North Carolina law recently towards the reinstatement of gun rights. From what I understand, I was talking to a woman who's currently a prosecutor here in Cabarrus County, who's running for a local judgeship, and she was talking. She actually brought up some changes in gun right and Second Amendment reinstatement laws around people being able to get their gun rights back. I haven't had a chance to look in it. Are you familiar with those new changes or any idea what she was talking about?
Nothing super recent. Um, there's a statute that allows you to get it back, get your rights back for nonviolent felonies. There's also a judicial procedure that you can use um,
Well,
to get your gun rights restored. Um, it's got to be a nonviolent felony.
yeah, understood.
Yeah, it's they're not going. Yeah, if you yeah if you've yeah, if you've shot into an occupied dwelling or something of the sort, they're not going to give you your gun rights back.
Most likely not. Most likely not. Where I stand with that in the Second Amendment is much different than most. I've told people like, guys, I'm a Second Amendment extremist for a reason because I believe that. So the problem I see with our current is we have people advocating for gun control and then people just saying no, not anybody going in the opposite direction, right? So I believe that the Second Amendment allows you, in my layman's interpretation, to possess anything up and into a nuke, right? And that's not true with the current state of laws. Not saying that. That's my personal opinion of how I interpret what the Second Amendment should mean, right? And I think that counterbalances because when you're just saying no and then you compromise and you meet halfway and you're only moving one direction, right? You end up 100% eventually 100% in the position that you were fighting against in the first place because you're never going the opposite way. So, do I actually want a civilian possessing a nuclear firearm, a nuclear armament? No, I don't. That's not. But by taking the extreme position, it means that the center isn't just moving one way all the time, right?
Well, it's the erosion of your rights one concession at a time.
Mm-hmm. So, and just
So
like you just go ahead, sorry, Matt.
it's I mean, there's small concessions, but it's one concession at a time.
Well, so Matt, would you openly say you're more conservative?
If personally, I'm more libertarian than anything else.
Okay,
I'm
understood.
diligently plotting to take over the world and leave everyone alone.
Understood. So, but would you say that you and the Supreme Court Justice Sotomayor are not closely politically aligned in your views? I'm trying to give you some because I'm going to say like I don't think that I think that even though you may personally politically disagree with some of her rulings and other things, you're still able to give praise to things that you find foundationally true in law, like you just did when she was talking to, when you were talking. What was the ruling you were talking about? I can't remember now. I had it in
That
my
was
brain.
the new civil death. It talks about the
Yeah.
civil and collateral consequences that attach when you have criminal charges and convictions, where you're treated differently for housing, employment, benefits, things like that. And what we've gotten into a situation as a country where we're so judgmental of people with even just criminal charges, whether you're acquitted or not, that it's used against you in other
Hmm.
areas. And that's honestly, there's so many laws at this point you can't walk down the street without violating
Hey,
law. I
three
mean, it's
felonies
it's
a day. I thought that was bullshit. I read the
it's
book.
ridiculous.
Yeah.
You know, but I think if we do anything as a society, what we need to look at is paring down the number of laws we have and setting some priorities on what's important and what's not.
Well, I talked
So
about sunsetting non-major laws, right? Like you should never sunset the murder laws, right? But having a sunset provision to precedents or to general laws or programs that are instituted by the state or the federal government, I think would require review and would allow us to have some. They're just not going to be able to make it to them all, and some of them will fall off the books, right? And if they're truly important, then those are the ones that will be upheld and constantly brought forward, right, or extended. And that was sort of an idea I had around that, because I do think there's a thing such as creating an overly prosecutorial environment inside of a country. So,
well, I mean, let's take an example, Alex. If you want to look at North Carolina's motor vehicle laws, the
mhm.
bulk of North Carolina's motor vehicle laws are in Chapter 20, and I think it's Article 3, and it's entitled the Motor Vehicle Act of 1937. I mean,
Yo,
we
I
we
don't
literally
again.
recently litigated, the state of North Carolina recently litigated a case about brake lights all the way to the United States Supreme Court.
Fuck.
I kid you not. This was a case where an officer made a stop based on a brake light being out.
Hmm.
The Court of Appeals got it and said, no, you don't have to have two brake lights. The way the statute's written, it says brake lamp, not lamps. So the stop's bad, so the drugs are out. They take it to the state Supreme Court.
So when he says it's out, that's called fruit of the poisonous tree. Anything. So if the initial reason why something happened for probable cause to be established is eliminated, anything that's rendered from that is bad. Sorry, go ahead, Matt. I apologize.
So, the issue ended up going to the North Carolina Supreme Court, and the North Carolina Supreme Court had to fix it. And then it went up to the United States Supreme Court. And it was decided not about it wasn't a matter of statutory interpretation at that point. It was about an officer's reasonable mistake of the law, and whether that was an excuse to justify a stop that was actually illegal under the law. The officer's good faith belief that it violated the law was enough to get the car stopped, even though it was not in fact against the law.
I
I
remember. I
bring
know
that
this
up.
case now. Yeah,
Yeah,
go ahead.
but I bring that up to talk about some of the areas in our law, like most of the Motor Vehicle Act hasn't been significantly updated. The DWI statutes have been, you know, but they need it to be, if you're talking about something efficient, DWI needs to be in its own group of statutes within that chapter. The DWI statutes are scattered all over the place. Your limited driving privileges are in one section, your substantive offense is in another. Then you got to fast forward about 40 statutes to get to your sentencing for the DWI. So, you're looking, if you're actually litigating one or defending one, you're not just looking at whether your client's guilty of the substantive offense, the driving while impaired, but you're also trying to prepare your client for what type of consequence is going to come. So
Mhm.
you're looking at several different things at one time. And the statute that deals with DWI sentencing is the most gigantic run-on sentence and paragraph that I've ever seen. It's literally just a gobbledygook.
Yeah. Well, without getting into specifics, for example, like with my specific instance, right, being able to have manual pleadings where I'm basically charged with every form of unlawful death in North Carolina. I'm literally charged with all of them, right?
Did they charge you with unsafe movement too?
Yeah, exactly, right. And it's like to a layman, if I like, I'm not a lawyer, right? When I first saw that, I was like, how the fuck? How am I charged with everything and yet nothing? Like, how that to me, like, law should be more easily understandable to the common man. Number one,
Sure.
and two, like, so I got that's why I got deep into it, because I between you and Pete and Todd, like, I got really interested and started to pursue down that road until I got blocked and found out there were no law schools for me to go to, and that I couldn't go back to school to finish up my original degree. So thank you, Charlotte School of Law. Moving forward, but like,
There are
it's
a lot
just
of people who could say that.
it's yeah, I was in the JDMD program, and then, you know, I was just doing it for the hell of it. I had no actual interest in law, and then you guys got me into all of it because it's very intricate, it's very interesting, and most people can't afford their defense. I mean, so everyone who knows, my attorney is Lisa Dubbs. She's exceptional. She's well respected here in North Carolina. She's a very well known lawyer. She teaches on capital defense. She does the reoccurring education that lawyers have to take on. I had to pay her $80,000, right, to get a competent defense, because it's the laws around it, the jury instructions around capital cases and self-defense are so intricate, and the ways you can open doors to allowing things in or keeping things closed out requires such a high level of specialization that, and it's all because everything that's ever decided never goes away, and that's the reason for it. So that's where I was going with that. So yeah.
Well, I mean, we could have a podcast just on laws in North Carolina that don't make any damn sense.
Well, I was just talking
Or,
about in general. Yeah.
well, yeah, I mean, but I think, going back to to the unanswered question about what I think about Justice Sotomayor is, I believe she was an Obama appointee, but I will tell you that I think she's the best Fourth Amendment judge on the Supreme Court right now.
Exactly. And so this
I
is where
think
we get where politics don't, law and politics just don't mix, guys. Like, there is good law and there is bad law, and shouldn't have nothing to do with your political stance. Go ahead.
no,
Sorry.
she understands Fourth Amendment law in a way that I think other justices miss.
Mhm.
I think it's a broader functional understanding. And I'll tell you who was an Obama appointee that I was really surprised about. I was very not derogatory, but suspicious of Justice Kagan being appointed, um, because she was a law professor who didn't have any actual litigation experience. But I can tell you that, having read her opinions, and the first opinion I read by her was a 1983 case, or a civil rights case,
Mhm.
where she talked about it, and I was very impressed with her thinking, and her writing. And I don't always agree with her, but I think she always reasons very well. She supports herself well.
Mhm.
So it really, to me, doesn't matter who put her on the court. And I will tell you that Justice Alito, who wrote this draft opinion, is my least favorite justice for criminal decisions. I think honest to God, having read some of the stuff he wrote, I really think he would have been okay with some things that Nazi Germany did.
Not going to say anything. That's right. You're not part of the federal bar. You don't have to worry about it. Okay.
Yeah, I mean, I'm not trying to criticize. I'm not trying to impugn his dignity or say he's incompetent. I'm not saying that at all. He's a very bright man, and in fact, this draft opinion is exceptionally well reasoned. And I've read some civil
Why
opinions
did
that
I
he's
say
done
that?
that were extremely well reasoned. But as far as his view of the criminal law and what, specifically the search and seizure area, I
Mhm.
think he falls very, very right, to very, very far to the right. And some
Mhm.
of the things that he has said in his dissenting opinions about criminal law, um, I think could be construed as being, you know, to me, a concerning view. As a defense attorney, they would be a concerning view.
Mhm. No,
just because I think it would allow, his views would allow too much police overreach.
yeah. So one of the things that I truly take issue with. So a lot of times when you see these Supreme Court nomination confirmations, do you need to go, my man?
No.
Okay. When you see these Supreme Court nominations and stuff, and they start attacking, oh, well, you haven't been a judge or you haven't been a prosecutor or a lawyer for a long time. It's not your ability to comprehend law is not affected by your. Now you can have a much wider understanding of how the law could be interpreted or how it could be, in your opinion, misinterpreted through experience in the courtroom. But it's not the end all be all for a Supreme Court justice.
No.
And at the end of the day, I think that there are instances where we have justices who are on the Supreme Court who may hold views that do not really, you can see in their justifications they're stretching a little bit. But at the end of the day, our legal system is imperfect, and trying to make it as perfect as we can requires us to step away from politics, to have these conversations as a rational people, trying to remove our emotions and personal opinions away from them in order to create a better judicial system, because our personal prejudices turn into prejudices inside of the justice system. And
law is logic.
Yeah, exactly.
I mean, it's logic and it's reason, and it serves people, but the function of law is to regulate interactions between people. And the funny thing is, you hear people talk about, with their lawyer jokes, and how the world would be better off without lawyers. My response typically to that is, try it and see how that works out for you.
It wouldn't have worked out well for me.
If you didn't have that, you didn't have the lawyers, you'd have mob justice. And we saw how well that worked out during the civil rights era, right? I mean, that worked out beautifully.
Yeah.
There's nothing better than meeting justice at the end of a pitchfork, right?
Mm-hmm.
So all these piddly disputes that people have without lawyers and a court system to go to, you settle that at the end of the fist or a gun, I guess.
Yeah, there's no civil society that can exist without lawyers and a legal system.
Right.
But in fairness, I remember where I was going. The problem I see currently with our judicial system is most judges are previously prosecutors. And in my personal experience, though that's not always a bad thing, they're not always bad. I have seen, in my opinion, what I've seen as an extreme bias by judges in favor of the prosecution, to believe the prosecution, to move in favor of the prosecution, and to act as if they're a prosecutor on the bench. And I'm not sure how we rectify that issue. And you're familiar of some of the political elements that I have issue with, such as, I think district attorneys being politically elected leads them to make political decisions in who to charge, right? I think that it can seem that way, even if it's not true. It could be not construed, but observed. There's a different word I'm looking for, but it seems observable that plays a role sometimes in people getting charged. That the decisions of superior court judges are sometimes affected by, doesn't involve a group that could possibly make me become unelected, right?
You mean like a large law firm?
Or a large family that founded a college and their grandson got murdered, or killed, according to them.
The term we're looking for is unalived.
Yeah, unalived. Yeah, I was gonna say it got murdered, and that's why I said according to them. I wanted to be very clear in that, or killed, depending on who you asked. And so that situation could lead to situations such as someone who's been to court 36 times in a row every other week, asking to show up once a month and getting restrictions that are far more worse than what most people would have expected. I think that there's other problems, such as you can sit and wait on trial for an unlimited amount of time almost in North Carolina, just by being put on the trial calendar, right? Unless you want to give up rights. So, such as, from what I understand, demanding a speedy trial in North Carolina requires you to surrender certain rights or other things like that in order to have that moved forward. Is that correct?
So if you speedy trial is kind of a illusion. It's a mirage for defendants, I think. Speedy trial to a lot of defendants means I'm going to get out of jail quicker.
Mm-hmm.
Um, that the illusion of that is that when you push for a speedy trial, you also inhibit your defense attorney from doing certain things that may actually, in the end, benefit you. Let's say, for instance, plus the passage of time typically always benefits the defendant, right? Let's take the classic example where, let's say, somebody is unalived during an altercation, but the only witness to the altercation who wasn't a participant happens to be a drug addict. Okay. Given enough time, that particular objective witness, I say with air quotations because oftentimes witnesses are not objective at all, but that particular objective witness might unalive themselves through their habit. So when that happens, it becomes beneficial to the defendant because the only story that's left to be told is the guy who's left standing.
Yeah. Delay is
And
inevitably
so,
to the benefit of the defense. Yep.
correct, which benefits him. So these folks that want this speedy trial, speedy trial, speedy trial, forget a lot of times that they may need certain witnesses to, to move on with their lives, to move away. There's a particular situation I'm thinking of in particular where a key witness moved to a different state and didn't want to come back.
Yeah, and subpoenaing across the state is damn near impossible.
Well, there's no authority to do it.
Mm-hmm.
If you've got a resident of Florida, North Carolina has no authority without going to the courts of Florida and registering a subpoena or an order. North Carolina has no authority to come get you there. So, that in this particular, in the case I'm thinking of, it made it much easier to get a plea bargain for this person based on that. So the delay, may not have been fun, but it worked out in this person's benefit ultimately. And that's what you miss with speedy trial. And sometimes defense attorneys need time to hire experts, gather evidence, and if you want a speedy trial, you may be going to trial with half your deck of cards.
Yep.
And at the end of the day, you may serve time in prison because you wanted it done quick.
Yep.
Better to be done right than it is to be done quick.
No, and I can agree with that, but back to the original topic, I took us down a rabbit hole there. It's just, I think that the prosecutorial, the focus and seemingly bias in favor of prosecutors, I'm not sure how we saw it. And it's actually proven out statistically. You can see that motions granted, other things like that in similar circumstance, blah, 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 blah. I think Justia did a whole, is the UNC School of Law. They have a great blog, and they did a little blurb about it to talk about what seems to be pro prosecution bias from judges who were previously prosecutors, right? And so it was very interesting. But no, I don't know how we solve for some things like that, like whether you make it where district attorneys are appointed on a rotation, a quarter of them every 4 years or other things like that. I don't know how you solve the judge issues. Judges need to be elected by the people in the county. Like it's because they're supposed to be representative of what people think is a good judge. I don't know if people are the best judges of that though, right? So because the law is so intricate.
I will tell you that that's something with which I vehemently disagree. I think it's a poor system for electing judges. I'm not entirely in favor of appointing judges with unlimited terms, where you can only remove them for specific things at the lower levels. I think at the Supreme Court it makes sense, but at least in the lower courts and in the state courts, Um, my view is that the average person doesn't know what makes a good judge
I
at
can
all.
agree with that.
They don't have
After
the
having seen
experience with the
the
courts.
yeah, after
Yeah,
seeing
and
the
I don't
legal
mean that
system,
as I
definitely.
don't mean that as a criticism, and I don't mean to insinuate that people aren't smart or that they're they can't exercise common sense. But when you're talking about what makes a good judge, there are things that you're not going to see on a leaflet or a pamphlet that make a good judge. Um, like you were saying with prosecutors, something that I personally believe is very important is for judges to have a balanced perspective, and that means having some civil experience as well, because
Hmm.
judges in our state don't really get to choose what kinds of cases they hear. So unless you're in a district where the chief district court judge or the senior resident superior court judge is going to allow you to only sit in criminal sessions as a scheduling courtesy, you're going to be dealing with cases all across the board. You may be in a criminal term doing a murder trial one week, and you may be doing a will caveat or a will contest the next week.
Hmm.
And having to make different rulings, and the areas of law are as different as night and day.
Yep,
And that,
absolutely.
for me personally, that's difficult. Um, I, that type of shifting is hard, because your mindset's very different. So I think, but if you're going to have to do that shifting, you need to have some experience, because judges who don't have experience in certain areas can do a great deal of damage.
I can
One of the
agree.
cases that you're familiar with involved, that occurred during your time working in the law office, involved a child who was removed, from a home,
Hmm.
um, and taken to a different state.
Hmm.
Um, and that was done by a judge who I have a lot of respect for in a lot of ways. But I think that was done very early in this judge's tenure, when this judge didn't have quite the experience
Hmm.
that was necessary to work on a case of that complexity, because of what it involved, and because of that lack of experience, there was a result that really had a
A traumatic
negative
effect for that
effect on the
child.
child.
Exactly. Yeah, we
And
saw that real time.
it took a lot to undo. So, and you can do a lot of damage if you're in an area where you don't have experience. And I will tell you that the one thing about the Rowan County Superior Court judge's race that I am extremely thankful for, and yeah, I wholeheartedly support Tim Gould. I've known
Hmm.
Tim a long time. I think he is a great legal scholar. I
Absolutely.
He has been impressive as a judge. Um, Even though
He's
he hasn't done civil law since law school, he's done a great job catching himself up. He's worked very hard. I've been impressed with his acumen in it. Um, but even if Tim were to lose in the primary, Mike Adkins is running, and Mike Adkins is a great attorney.
hmm
I mean, he's a good guy. He's a great attorney. So Rowan County's very blessed, because whoever we end up with, if we keep Tim, even if we get Mike, we're going to be in good shape. We
absolutely.
have two really good candidates.
Yeah, and I'm familiar
And
with both of them, and I like both of them. So yeah, absolutely.
so, but they both have proven themselves. And Tim is really the exception to that prosecutorial bias that you see.
Yep.
Um, I think if anything, he's about as middle of the road as you get, and he thinks very, very well.
Yeah.
Um,
He never did actual defense. He never did any, and he was
no,
always a prosecutor. Yeah, absolutely.
no, but he understood it.
Yeah, but
Um,
he's the only person at the courthouse who kind of on that side of the aisle who kind of treated me like a human being. That's why I liked him. And
you know
yeah.
who else is really good? Paxton Butler's very good.
Mhm.
If Paxton wins, and I'll be honest, I'm hopeful he does, because Paxton has a very, very good viewpoint. He's very balanced,
Is he going for district or something?
district attorney,
Okay.
and he's got a lot of experience. I've always had good results with it. Very similarly with Tim when he worked in the DA's office. Tim was approachable. Um,
reasonable.
If you had
If
a
you
legal
had good
argument,
facts, yeah. Go ahead. Sorry.
yeah, even if you had a good legal argument, he'd work with you. Yeah,
Yep.
there's not one time that I brought something to Tim or Paxton and said, look, I have a problem with this. Here's what I'm thinking. That they did not work with me and try to come to a mutually beneficial resolution, both for my client and for the state.
Mhm.
Um, and so that I'm really hopeful that that we get that as a combination, because I really think we're going to be able to do some good things, and I think we're going to finally have if Paxton gets in, I think we're finally going to have some good discretion at the DA's office, and we're going to be able to move things quicker, because we need
Mhm.
to be focusing on real issues.
Yep.
And when everything's a priority, nothing is, right?
Yeah. Absolutely.
So
Just so you
that's
guys
what my
understand what that's about, if I could just give me 1 minute.
oh, absolutely.
So, guys, for example, sometimes you have people who are poor who literally sit in jail as long as they possibly could serve, right? Every day they possibly could serve if they're found guilty. Now, the justice system is supposed to be not only about punishment but also about rehabilitation, and that's been founded in multiple decisions throughout the years, unless that's somehow randomly changed in the last 5. Um, but what happens is that you'll have prosecutors, for instance, who will hang on to petty misdemeanors, right? Even though the person served every day they possibly could, and will not dismiss it, right? And that's what he's talking about with discretion. In the better part of discretion, sometimes, you know what, he's already served his time. All it's going to do, we're going to put him on probation. He's going to fail probation because he's not going to have the money to do it. He's just going to come back before us a bunch of times. It's going to just take up a bunch more of the county's time and budget, and it's not going to serve anybody. He's not going to do any more time from it. He's just going to keep coming until they say, you know what, we're just going to terminate his probation. Was it unsuccessful? Can't remember. I think it's
Well,
unsuccessful.
think about it this way, Alex.
Yeah.
You got a guy who's charged with, say, stealing something from Walmart.
Yeah.
And he's been in jail for 45 days.
Yep.
Okay, he could do 120, but he's already been in jail for 45 days. And while he's sitting in jail, we need to create some space for these guys that went up and shot up a house the other day, to get them off
Yeah.
the street. So,
Yeah. I
let's get
remember that
him
issue.
out, because, he's a petty thief is all he is. And it doesn't make it right. And I'm not trying to minimize what he does, but in the grand scheme of things, you're triaging cases and what's important. And when you've got a 15,000 case backlog and you're warehousing several thousand of them in probable cause court so that they don't affect your numbers, meanwhile, you have real crime going on in the streets, there are some things that you need to cut the wheat from the chaff.
Absolutely. And the other thing that I take issue with is that we there's no point in prosecuting those types of people, but also just the our court system is broken, in my opinion, in this one space, that our court system was never meant to solve 99% of its it's actually like 98.2% of its cases through plea deals, but unfortunately we do, right? And
Mhm.
if every criminal or person charged with a crime realized that if they just demanded a trial, the entire court system would fall apart in a matter of weeks, nothing would move, everything would be empty. Like, it just, being able to triage cases would lessen that factor. Even the fact that that is a reality is concerning to me. That if people actually demanded their constitutional rights, the court system would collapse in on itself is disconcerting. So
It would, but it's unlikely, and I mean extremely unlikely, to ever happen, because people are selfish. They don't care about the greater good of demanding a trial when they've got an opportunity to get out of jail tomorrow.
yep, we've seen that. People
I
who
mean,
absolutely,
so
we know, hey, I could get you off. It's just going to take some time. No, I want out.
oh
Like,
God, yeah,
yeah.
I've withdrawn from cases where people have demanded to plead guilty when the case against them was so weak that I didn't feel that they could ever be convicted. And it was something that I knew I knew just looking at the the state's summary, the state's case, that they could never prove at trial.
And
And
that's where discretion comes in. Why are you and so there's another saying on the prosecutor side, and you got to understand that too, is that you don't get fired for the cases you don't that you try. You get fired for the cases you dismiss, right? And we have a perfect
right.
example of that in a close associate of ours. So, though he's made a successful practice for himself afterwards. And so, or whatever you wish to say. But at the end of the day, that political effect is where we go back to how we elect DAs, how district attorneys are decided, and how politics and the power of individual groups or large law firms can sway justice so that they don't feel comfortable using discretion. So I think I think they're on the other end of a pointed sword too. So it's not just one way. I want to be clear on that. So
Well, and I think I think that goes back to where and this is something that the associate you and I were speaking of. He and I disagree on that. As to how judges should be, how judges should be decided. Um, and he's been around a long time. I've been in the criminal justice system a long time, but I also grew up with a father who was an attorney, and I got to listen to a lot of the things that he would say, and his frustration with cases where he believed he was right, that he really, and he was frustrated because he felt the law was clearly in his favor, but he lost because he was up against a big law firm that would donate to the judge. Um,
yeah.
And those are and that hurts real people.
Mm-hmm.
Because these cases are about real people. It's not always about this concept of win loss, clarity of law, stare decisis. We got to remember that there are real people that are involved, and when a decision is made based on a political leaning or a political loyalty that hurts a real person, I think there's a problem. And that's where appointed judges at least have some insulation from that influence.
Mm-hmm.
Now, because they're not subject to removal based on a decision they made.
So
Even they
go ahead, sorry.
they could make a decision that was unpopular but maybe right. Remember, just because everybody's doing it doesn't mean it's right.
So my personal opinion is that I believe that the local county bar of defense attorneys, right, and the prosecutor's office should each have a delegate in
Mm-hmm.
this, and that those, and then you have a tiebreaker who I don't know who that would be, whether it's a magistrate or some. Well, no, it would have to be an unelected official, but basically tie. And those two would basically get together and decide amongst the people who put their names forward, right, who they would like to select as the next, or just make it well, you can't make people leave their practices, right? So you can't just be like, well, you
No,
have to serve if you're chosen, right? So, people put forward, and then those two are the ones who basically go out and they say, hey, we'd like you. We've decided, hey, we'd like you to become a judge. Was that something you're interested in? And then out of the people that say yes, they make those decisions together, and I think that would create a more fair, because if you said, oh, well, all the bar attorneys get a vote and the prosecutor, well, the bar attorneys would be favored by all judges because they're the biggest, right? The
mm-hmm.
defense attorneys outnumber prosecutors. And so I just think
Well,
that
but
that would remove
prosecutors
it.
are members
Yeah.
of the bar too, Alex.
Yeah. Well, I meant the defense bar. I apologize.
Right.
So yeah, I apologize. Yeah, they're a member of the bar. That's okay, guys. So something to remember. You know that little place in front of the last pew, that bar in front of the last pew when you're sitting in court? That's called the bar. To step in front of the bar, you have to pass the bar. It's it's a little weird. At
Or be
least that's
immune to tasers, one of the two.
that too. So that's when you're talking about passing the bar. From what I understand, that's a literal phrase referencing that bar that separates the audience from the court. So, yeah, but it's. I'm sorry, went into a random thing there, but I think that there has to be some other way where we can remove the politics so judges don't feel threatened in certain situations, and that's a human characteristic. It's very hard to be immune to. Some judges absolutely are, and I admire them. The Hammer, for example, I'm not going to give that person's real name because I don't want to talk about a North Carolina judge at all directly, but he's called the Hammer. He will sentence you to life in prison, but he is exceptionally fair. Now, once you get convicted, he's going to put the max on you. That's why he's called the Hammer. but or the grizzly or the bear. Some people reference him differently, but he's in the 19th Circuit and he is a beast and he will sentence you to the max. But he's very fair. Example: the judge who was in my I'm going to be very careful here. The judge who was in my bond revocation hearing, not taking judicial notice of just random things they put in the filing, right? Very fair. There are a lot of judges who would have just taken the prosecutor or AG's word for it and taken it as, and just discarded all the rules of evidence and just said, you know what, it's a motion, it's not a trial. I'm just going to take what they say as word, right? But judges like that are not the norm, they're the exception, and that's what I find issue with. But anyways, moving forward. All right, guys. Well, it has been long. We are an hour over our normal time. I appreciate all of you for coming. Please like and subscribe again. Thank you, Matt, for your time, for going over with us, for continuing this legal discussion. We appreciate you. Have a good night, y'all. I'm going to end the stream. If you can hang out for just a second, Matt, and I will see you guys later. Remember, guys, as I say every night, remember that you have intrinsic value as a human being, no matter what race, creed, color. You have importance just by being alive. I love every last one of you. Have a good night. This has been the Cardboard Castle.